in the world today. And I think that this piece of renewed legislation will go a far way in addressing some of the shortcomings that we have. My understanding is at the last committee meeting, the Office of the Director of Public Prosecutions provided a response to the Major Organized Crime and Anti-Corruption's recommendation that the category of officers who could make a forfeiture application be extended to include clerks of the court. The office pointed out that an anomaly was created in respect of Section 22 of the Cybercrimes Act, where the office had to intervene post-conviction for forfeiture applications if a conviction were made in the parish court. Mention was made of Section 24/2 of the Dangerous Drug Act and Section 20A of the Quarries Control Act, which empowers a prosecution to apply for forfeiture of the instruments of a crime. It was suggested that an amendment be made to the provision of the act similar to these legislations, which makes reference to the prosecution instead of the Director of Public Prosecutions. It is my understanding that the committee supported the suggestion of the office, and the committee's draft report was updated to capture the response. Also, a commitment was made by the team from the office that it would send a formal response on Section 20 of the Act. Also, it was suggested at the last meeting that the Digital and Cybercrimes Unit of the office could draft a brief protocol to provide guidance to the police and clerks of the court in relation to the said section. The office was asked to provide an update on the matter. The ministry has not received a response as yet from the office, but I don't think that this should detain us, as basically this has already been accepted. And obviously we will follow up to make sure that the promised protocol is received. Also, the proposed Section 9 of the Act was revealed to the office. It was suggested that further consideration be given by the committee on same. I suspect that the LRD will present on that today. The issue of the definition of damages, particularly in relation to the psychological injury and mental injury, was raised at the last meeting. MSET was asked to consult with the Ministry of Health on the said matter. I was advised that the MSET prepared and sent the letter to the Ministry of Health, for which I've just received a copy. And obviously, if we have not received that, I will follow that up also. I suppose Ms. Campbell from MSET will be able to guide us on where we are with that. And lastly, the committee is to continue its review of its draft report, commencing at findings and recommendations on page 5 of the report, for which I'm going to ask Member Gale at that time to continue taking us through that as he had started, and obviously is au fait with it. So, as I said before, it is hopefully we are seeing the winding down of this joint select committee, for which obviously once it is agreed that the review is complete, the report will be sent for members' signatures and then obviously for tabling. So I am very, very confident that if we work diligently, we should be in a position, if not by the end of this meeting, which we have an hour and 45 minutes, definitely the next one, which is next week, which is at the beginning, as we know, of the new financial year for government, which obviously will allow us to move with alacrity during this financial year. All right, so the reading and confirmation of the minutes of the meeting held on March 22nd. I don't know, Member Gale, you had shared that meeting. I don't know whether you want us to defer it until the end, if members would like an opportunity to still go through it, or we can take it now. I'm open, as I wasn't present, so obviously.
Well, we could defer it until the end, just to go through the rest of the proceedings.
All right, great, okay. All right, so we'll do that, and also matters arising from the minutes. We'll take that at the end of thing. So today's business obviously is a review of the committee's draft report. So before we get, I think Ms. Campbell is going to represent CTD Joaquin Murray, but maybe what we could do is ask the LRD to take us through the Section 9 the Section 9 before we actually go into Ms. Campbell taking up from the recommendations and finding the recommendations. Are you okay with that?
Yes, Chair. Okay, this is Erica Simon from the LRD. As was mentioned, in the last meeting, the DPP had given an opinion on the proposed redraft of Section 9, in essence, that it was too wide. Members of the technical team met with them further to try and to see whether or not we could address their concerns. The concerns could be addressed by a further revision of that redraft, and also to share with them the research and the jurisdictions that had been reviewed in making the proposed redraft. After that meeting, we were not able to remedy that section. In essence, it was just thought to be too wide, and that the qualifying words that you would see that are in Section 9, subsection 1, paragraph A, the use of those words obscene, threatening, menace, some qualifying words are needed. That was the overall view. And so instead of a replacement as was being proposed, it is now being proposed that the section be amended instead. And it would be amended to include a new subsection to address intimate images as had been proposed by the Office of the DPP. And in conjunction with that recommendation, it was also proposed that the word obscene be removed, as the DPP's office thought that with a standalone provision addressing intimate images, that the term would not be needed any longer. It is our view, though, at the LRD that the term obscene isn't restricted to sexual images, although it's predominantly what comes up in case law when one looks at what is obscene. We think it is and can potentially be wider than that at some point in future, and so the term should be retained, just to make sure that we don't close out anybody from the provision by its removal. We recognize that there is the Obscene Publications Act, which could cover those persons if the term was removed. However, at present, the period of imprisonment that can be imposed under that section is below the threshold to bring it within Section 4 of the Cybercrimes Act. And so if the committee is minded to accept the proposal to delete obscene, then we would suggest that a further recommendation is made for the urgent update of that legislation to ensure that, should it be needed, something that is considered obscene, which is not necessarily sexual, which doesn't fall under the new proposed provision to deal with sexual images, could be prosecuted as a cybercrime. The other proposed amendment would be to address the issue that the Office of the DPP has found has arisen with the use of the phrase sending in the existing provision. It is observed that in practice, you don't necessarily have to send something from one person to another in order to cause the person that kind of harassment, to cause them that kind of injury under the Act. You could simply post it on a public space like a Facebook, or you could share it on your status on WhatsApp. And those kinds of ways of communicating information wouldn't necessarily be captured by the term sending. And so we are suggesting that either sending is replaced with publish, or sending is defined to include publishing, or in addition to saying sending, as the provision already does, we would add publish, just to ensure that those other means of communicating information, of sharing information, are captured as well. So that is in essence what is being proposed for amending the section, instead of replacing it as was initially proposed.
Members,
Mr. Chairman,
go ahead.
I just want to say that I'm supporting the keeping of the word obscene, especially with the explanation given a moment ago. And in terms of sending, I do agree that we have to change, either define the word sending or change the use of the word to facilitate online social media posts. Thinking off the cuff, I would support defining the word sending rather than trying to find another word that would encapsulate everything that we're trying to suggest or to indicate with the term to be used there.
Noted. Members, any other members?
Chairman, I take note of the use of the term publish, and I would want to seek some clarity in terms of this new insertion, as opposed to sending.
So you may, I'm not sure if you'll recall from the redraft that was being proposed initially, the publish was being defined in relation to data to include sending, transferring, posting, disseminating, or otherwise providing access to data. So we're thinking of something broader like that, as opposed to just simply sending, because of the way information is communicated and shared, and because of the concern that the DPP expressed with the use of sending, that sometimes because of how we share data now, the person doesn't fall under the section necessarily.
Okay, thank you.
Chairman, I have a question I just want some clarity on. If, for example, you're in what you would consider a private WhatsApp group, or sharing a message that maybe you consider private, and that becomes something which becomes public, would that be captured as sending or publishing? I'm asking LRD if they can guide me here. So I send somebody something private, which could be considered malicious to somebody else, but it is within the context of what I consider to be a private form of communication. And then that gets put out there in the public domain. Is that considered under the definition of publishing or sending?
I don't think it would fall under that, because the person would also have to have sent it with the intention of harassing it. So you had, as in the example, the person had shared this in a private group for some other purpose. I don't think such a person, if the information is then later shared by somebody else, would qualify as having sent it with the intention of harassing the person concerned.
Okay, all right, thank you.
So members, based on the input that has been received, LRD, are you satisfied with the instructions?
Chairman, could I just ask a question following on Member Robinson's query a while ago? Because in that scenario, if LRD could guide, there really would be two potential offenders. One would be the person who sent the message, who my understanding is you're saying they would not have sent it with the intent to harass, so it's not, so there would be no action against them. But for the person who disseminated the message, would that not be captured as having that malicious intent?
In my view, that person would fall to be similarly construed, because if I shared it in the public space, again, not with the intent to harass the person, I would still not be liable under this section. I would have had to have the intent to harm that person, to harass that person, to be prosecuted under the section. So even if I then took something from a private space, put it on a public space, that intent has to be there.
Okay, thank you.
All right, so are we satisfied with the response to the LRD in terms of this suggestions made? LRD, you're clear? Oh, is that SG, you want to come in?
Yes, thank you, Chair. Well, I'm not clear on what exactly the committee has agreed on, so I wanted to understand if there is a change and what the change is.
So member Campbell made a suggestion in relation, and also member Gale. So that's the question I'm asking the LRD. How does that change what is being proposed?
I didn't notice, based on what was said, that there was a fundamental change in what is being proposed. It's simply a matter, I think, of the committee deciding which approach they favored. And what I picked up from Senator Campbell Rodriguez was that she would prefer defining sending rather than replacing it with another term. And I think she also seemed okay with the idea of a separate provision, which would really be based on the meeting, subsection of Section 9, addressing intimate images. I think Member Gale was just asking for clarification as to what we meant by when we were proposing including publish in the provision.
Mr. Chairman, I think she has captured what I intended, except I want to be very specific about the fact that obscene, I am suggesting that it remains only because, yes, we tend to use it to refer to sexual acts or sexual actions. However, given where the world is going right now and what is happening, we may not think of obscene in another way, but we should leave it there with the aim for it to be used for other things other than those relating to sexual actions.
So okay, so the question is whether or not that is accepted by the committee members. I haven't heard anyone object. So do I take it that that suggestion by Member Campbell Rodriguez is accepted by the committee? Okay, so there you have it. So you're clear now, LRD, you're clear now? SG?
Yes, Chair, we're clear.
Okay. All right, so can I ask now, Ms. Campbell?
Sorry, Chair. It's a number of things were said, and just for the record, is it that the decision of the committee is one, not to use the word publish, two, to use the word send but define it, and I don't know who is going to provide the definition of send. Three, to leave the word obscene, where it is. Four, not to propose or recommend any changes to the Obscene Publications Act. Because a number of things were said, so we just want to be very clear about what is going to be recorded in the report, and what the proposed amendments really are. And then I also heard another issue about including a discrete provision, and I'm really not clear about intimate images, and I'm not clear what is going to be the content of that discrete provision. So from our perspective, we're still not very clear on the committee's decisions.
Mr. Chairman, up until she started speaking about discrete decisions, that is what I had suggested and the committee has accepted. After discrete, I'm not clear what you're talking about, so I can't speak to that one.
Was that the matter Member Robinson brought up? Julian, that's your matter?
Sorry, Ms. Simon said there was also a proposal for a discrete provision dealing with intimate images, and that's what I'm not clear on.
The CPC had a hand up.
Go ahead, Ms. Grant.
Thank you. I'm just querying the decision, if there is one, to use the words, to keep the word send rather than use the wider term publish, because if the intention is to capture things which would normally not be understood by the terminology of send, I think that publish would probably be a better term to use, because it could accommodate the wider concepts, which would include the posting of messages online. So I didn't have a difficulty with the proposed definition that legal reform had done in their redraft. That's my view.
I would support publish versus send in this particular case. And I would say if we are maintaining the word obscene, we have to define it. This section is the most contentious section of the entire act, and a lot of people don't really understand it. So if for many of the terms, I think we have to find a way to define what the terms actually mean, so people know what is in and what is not in, and what is covered by the legislation. But I definitely support publish versus send.
Mr. Chairman, I agree that we should define obscene. However, I disagree on using the word publish, because if I send, I prefer us to keep the word send, but if we choose to go with the word publish, I would still ask that we define it. It's about persons understanding what we mean, because if I send a WhatsApp message, I don't consider that publishing, even though it may be. And maybe the legislation requires it to be so, but I think whichever term we go with, it needs to be defined, whether it is send or publish.
What's the harm in having send/publish?
Chairman, if I may, before you make that decision, just to probably add another option, perhaps use the word convey, because I think that traverses all concerned, and I think it is actually encompassing of persons who may not intentionally send, publish, but also pass it on to someone who may then do the sending or the publishing. So I'm suggesting convey.
I think that might make it suffer a little more. I think the critical thing here is the definition, whether it's send or publish. It must have a definition that everybody understands.
Any word we use will, I think, needs that definition. Agreed.
So I was asking a question a while ago, if the two words send and publish, why if there's any harm in putting both of them, send/publish? Does that complicate matters, or does that make it simplify?
Chair,
Yes.
I think it would complicate it because there would be a need to define both. I think once we choose one term and we define it appropriately, that would cover the concerns.
Well, I would suggest publish and make sure that the definition encompasses the concern of Member Campbell Rodriguez.
So the definition that we had initially proposed for publish was publish in relation to data includes sending, transferring, hosting, disseminating, or otherwise providing access to data. So that's something that could be considered.
Yeah, I think that.
So the
that
term
that
publish.
covers it for me.
Sorry, go ahead, Julia.
No, I say I like that definition that you just, because it indicates that it includes sending. Yeah.
Yes, there you go. And so that would treat with both words
That's correct.
defined in one.
That's correct. And that definition definitely does cover the both concerns, for sure. Can we go with that, members? With publish with that definition that the LRD just shared with us? All right, so we'll go with that LRD. The SG, is there anything else that you're still unclear of?
I think there was reference to the what the intimate images provision would be like. And I just want to refer to the DPP submission. They were guided by a provision from Canada, which provided that everyone who knowingly publishes, distributes, transmits, sells, makes available, or advertises an intimate image of a person, knowing that person depicted in the image did not give their consent to that conduct, or being reckless as to whether or not that person gave their consent, is guilty of an offense or something like that.
Any comments on that, members?
So the critical thing here turns on the word consent. So could there be a scenario where two people in a consenting relationship, they share images, they're fine with sharing the images over, okay, but the issue would be if the person sends it on, okay, no, I think I'm good. Because it would cover this. Two people could be in a relationship, they share the images, which are private or intimate, but they have not given consent for the other party to share it either publicly or with a third party. So it would still cover it.
And in that provision that the DPP had recommended, they define what intimate image is. So it's defined as meaning a visual recording of a person made by any means, including a photographic, film, or video recording, in which the person is nude or exposing his or her genital organs or anal region or her breast, or is engaged in explicit sexual activity, B, in respect of which at the time of recording, there were circumstances that gave rise to a reasonable expectation of privacy, and C, in respect of which the person depicted retains a reasonable expectation of privacy at the time the offense is committed.
Let me ask you something here. In scenarios where people have traffic accidents and images are shared with them in, sometimes the people are dead and sometimes they're badly mangled. Can somebody be considered guilty of that particular provision there?
I don't think so, because it would have
because the image could cause great distress to the family members and others of somebody who don't even know their family member is in an accident. The person is in a state which, you know, they wouldn't want to be seen, and an action could possibly be taken by either that person if they're still alive or a family member.
Well, I don't think so, because I'm rereading the definition of intimate image, and it suggests that the person was actively involved in the recording being made. The scenario of the accident scene is I am recording somebody who, because of the accident, is now exposed. They would not have been actively involved in the recording. So I don't think it would fall under this provision, but this is just an example of what it could look like. I don't think we necessarily have to follow this to the letter. It was just to give you members an idea of what a provision on intimate images could be like.
Member Robinson's point
What Member Robinson
is
has
well-
raised is another area of concern. Whilst not captured in what would be regarded as being intimate, it would suggest, in my mind, that we need an area to treat with that, because that is an area that concerns has been raised by the public in terms of the unfortunate transmission of such events. And maybe if we can find a way to capture that elsewhere, outside of the definition of intimate, we may want to consider it.
I agree wholeheartedly. It's that the situation that Member Robinson raised is becoming more and more frequent, and it's very disturbing. Even for people who don't have any knowledge or relationship with the deceased or the injured. It's just to me, it's just not right. So I support Member Robinson and Member Gill that we should find somewhere to put that in to try and deter people from posting those images. I don't know if you have any suggestions, LRD or SG, in terms of how we could do that. It can't be. It's not too difficult in terms of what we're trying to achieve. Could I ask that we do some work on that and don't detain ourselves trying to solve it here, but obviously try for the next meeting to come back with some suggestion in terms of how we could capture it in the existing or to make a provision for it. But I definitely think of not capturing this would be a injustice in terms of the overall report.
Well, we could do some further research to see if, what that could look like, but to the best of my recollection, at the moment, I think it may be only one jurisdiction that has a provision like that, but I will look further and I can report at the next meeting.
Okay, members, you agree on that?
Yeah, if there's one, there's one. Let's look at it.
Yeah, the truth of the matter is that that's something that never used to happen. And now all of a sudden it's become almost a daily occurrence.
Mr. Chairman, a question. If we're not happy with the one definition that exists, what about drafting our own? Because this is a matter of concern. Is there any problem with us drafting our own wording for that?
I don't think so, but as a layman, I would defer to the legalese. But I'm sure that we can find some jurisdiction that has it and tweak it. I think right in the next meeting, we should be in a position to have something.
Noted, Mr. Chairman.
Just to clarify though, for the purposes of section 9, the agreement is to keep obscene, to replace send with publish, but to define it, and to insert a subsection addressing intimate images, and also to recommend that the Obscene Publications Act is updated so that the penalty is updated, the period of imprisonment is updated so that offenses committed in cyberspace can be prosecuted under that section, under that legislation as well.
In my mind, the fact that we're keeping the word obscene, it wouldn't be the recommendation for that act to be updated, wouldn't be for the view that cybercrimes be able to be charged under it. If in this legislation, we have a situation where obscene crimes that are, or acts that are seen as being obscene can be charged under this piece of legislation. But maybe I misunderstood.
Members, any input on that?
The SG's hand is raised.
SG, go ahead.
Yes, thank you, Chair. I would prefer the position as stated by Member Campbell Rodriguez, because to amend the Obscene Publications Act is actually very complicated. And I think the amendment would actually go against the policy of the government of Jamaica. The first thing is, it is not an act that falls under the purview of MSET. More importantly, it has been given constitutional protection. What do I mean by this? Section 1312 of the Charter of Rights includes a savings provision, and there are only 3 things that are saved from being found to be inconsistent with the Charter, and one of them is obscene publications. If we do any amendments to the Obscene Publications Act, it means that we remove the savings provision, the protective quality of the savings provision in the Constitution. And as far as I am aware, that is not the policy of the government of Jamaica. As far as I am aware, the policy is that three matters are to be protected against challenge, one being the obscene publications, which would include the Obscene Publications Act.
Noted, SG. So what you're saying is what we are proposing.
Is what, yes, what Member Campbell Rodriguez said, which was you provide for whatever you're doing about obscene images and so on under the Cybercrimes, and you leave the Obscene Publications Act alone.
You have said it perfectly.
We will be guided by you, SG, as usual. All right, LRD, you clear on that?
Yes, Chair.
Okay, so this matter in relation to Section 9, you're clear on the directives of the committee?
Sure. I understand it to be that we will keep obscene but define it. We will replace send with publish and also define it, and there would be a separate subsection addressing intimate images.
I'm sorry, did you, I didn't get that the decision was to define obscene, and I doubt that it is capable of a definition that wouldn't have.
I thought that's what I understood from one of the members.
You want to clarify that, SG?
Well, so ultimately that's a decision for the committee, but I can tell you that it's a very difficult term to define. In fact, most jurisdictions do not define obscene, and it is left to the ordinary meaning and interpretation. There are some jurisdictions where you may have some case law that assists in the interpretation of obscene. The problem with with defining obscene is, you see, it depends on the morals of your society, which change from time to time. So what was obscene in 1920 may not be obscene in 2020. And I think that is perhaps part of the reason that that word is not usually or generally defined.
SG, you know that obviously we are guided by your comments based on obviously the office that you hold. So we don't want to reinvent the wheel and try and do what has not been done before. We just want to make sure that obviously the concerns are noted in terms of why this suggestion is being made. Member Campbell Rodriguez.
And Chair, perhaps with any concern your committee members may have would be addressed to the fact that there is a decision to include provision dealing with intimate images, which I think carries provision that much further. So even if you thought there would be a gap, I think the inclusion of that new provision would, I think, allay some of the fears and concerns.
Mr. Chairman, I agree about not defining obscene. I'm not sure if I'm the one who recommended that it be defined, but if I were the one who did so, I'm fine with it not being defined based on the response just given.
I think I recommended it, but I acknowledge the SG's explanation, and yeah, we work with what the SG has said.
Okay, members. All right. So LRD, you're clear now, finally.
Yes, Chair, clear.
Okay, thank you very much. All right. Miss Campbell, sitting in for CTD Murray. I turn over to you, and then of course ask Member Gale to continue taking us through the finding and recommendations after. Over to you, Ms. Campbell.
Good morning, Chair, members, and colleagues. The update from the ministry is that we've made the request of the Ministry of Health and Wellness to consider the deliberations of this committee in relation to the expansion of the definition of damage to include the broader term mental injury, and to indicate to them that this may require the amendments being done to the Mental Health Act. We are actively following up on that, and we will advise the committee as soon as we have received a reply so that we can begin the consultation in respect of that particular matter.
Sorry, Ms. Campbell, just to say that I'm in touch with the PS for Health, and he has assured me that they're on it and we'll get a response in short order.
Very well, Minister, thank you.
Anything else, Ms. Campbell?
No, Minister.
All right.
Thank you, Chairman, and thank you, Ms. Campbell, for that update.
Sure.
I must be a happy member today, Chair.
I am always a happy member, colleague.
Well,
Always.
happier.
I'm gonna make her
Thank
even
you.
happier. I'm gonna send her a copy of the letter. I'm gonna send Member Longmore a copy of the letter to Minister Bell to make sure that she's satisfied.
Much appreciated.
All right. So Member Gale, who chaired the last meeting and started taking us through the draft report, the findings and recommendations. So I will ask you to continue, Member.
Thank you, Chair. And I'm reading now from the second draft that would have been sent to us, starting with page 5, under section 4, findings and recommendations. A specific recommendation. Section 1, short title, your committee recommends that no amendment is necessary for this section. Under section 2, that speaks to interpretation. This section provides the interpretation to key terms that are used throughout the legislation. Based on concerns raised by stakeholders, your committee wishes to make the following recommendations. Computer. We questioned if the Internet of Things was covered in the definition of the term computer. Members of your committee were informed that the Internet of Things was considered in like form to a computer system in cybercrime and cybersecurity legislation. We noted that the reason for same was that devices connected to the internet were susceptible to the same type of activities that cyber criminals perpetuate against computer systems. One stakeholder suggested that clarity should be provided on whether the act is intended to cover only crimes over a network or to cover crimes committed using an electronic device generally. The stakeholder also recommended that a definition be included for data storage device. Your committee was advised that the act intends to cover crimes committed against or using a computer, whether the computer is a standalone device or part of a network, as articulated in section 3 to 9. Regarding the inclusion of a definition for the term data storage device, we were advised by the MSET that although the term or a variation of the term was defined in some cybercrimes legislation, in other countries, there was no need to define same in the act, since the definition of terms such as computer, data, electronic, and electronic communication systems inherently provided for electronic device that store data. Your committee recommends that no amendment is necessary for the definition. Under damages, we noted that suggestion of some stakeholders that the term damage should be expanded to include different types of damages, such as psychological injury and mental injury / distress. In our deliberations, your committee considered whether to include the term mental injury or psychological injury in the definition. One member of your committee expressed the view that the term mental injury should be used in the definition, since mental health encompasses all psychologically related issues. But psychological injury might not encompass all possible mental health components. The LRD advised your committee that the court has viewed mental injury as a psychiatric illness in civil litigation. It was noted that the term was only defined in section 27 of the New Zealand Accident Compensation Act 2001 as a clinically significant behavioral, cognitive, and psychological function. Members of your committee were advised that based on case law, it was found that mental injury was considered as a disturbance of the mind and is serious and prolonged and rises above the ordinary annoyances, anxieties, and fears that come with living in civil society and need not be proved by medical evidence. On the other hand, psychological injury or harm was considered an aggravating factor in determining the appropriate custodial sentence, and the court could make inferences based on information contained in social inquiry report, including statements from a victim. Your committee learned that the courts considered mental injury or harm as a recognized psychiatric illness. Having considered the issues, we agree that the term to be considered in the provision should be carefully decided, since it would have implications on how the offense would be prosecuted. We support the view that there should be wide consultation among medical, legal, and judicial and academic experts to resolve the issue of the type of injury that would be appropriate for inclusion in the Act, and that the term be defined once a decision is made based on the preferred definition. We recommend that the Ministry of Health and Wellness consider amending the Mental Health Act. On the function, we noted the recommendation from one stakeholder that the definition should include addition and modification, given the term deletion was provided for in the definition. The MSED team advised us of 9 jurisdictions and their cybercrime legislation, and indicated that 5 of them did not define the term function, although the term was used in their legislation. The team further pointed out that the other 4 countries defined the term in the same way as it was defined in the Act. We were informed that no evidence has been found where the term function was defined to make specific reference to addition and modification. However, the use of the word includes suggested that the term was not limited to the terms referenced in the definition. So as a result, your committee recommends that no amendment is necessary for the definition. Under key, your committee noted the typographical error in the definition and the term key of the term key, and recommends that the word date be changed to the word data. We also recommend that the term should be defined to make reference to electronic and digital keys. Under section 2, subsection 2, the word access. Your committee did not accept a recommendation that was made by one stakeholder to amend the definition of access to include words, any function that willfully and knowingly initiates, as the respective offenses provisions already articulate the requisite mens rea of intent. We also did not accept a recommendation to amend section 2, subsection 2A to include the word create, as we were advised that in the context of cybersecurity or information security, one could not simply create anything. One simply add to an existing data set or framework. It was noted that the term alter sufficiently covered the concept of creation or modification. One stakeholder expressed the view that the word storage was used throughout the Act, and it was unclear what was meant by the term. It was suggested that the term should be defined. We observed that the term was used in section 2, subsection 2B. We're of the view that the word should not be defined since it is used throughout the Act. Since it is used throughout the Act, the context of other terms that are referenced in relation to a computer. One of the issues that were raised by members of your committee was how persons who found vulnerability in system and reported same would be treated according to the provisions of the legislation. The MSET advised your committee that the unwitting discovery of vulnerabilities should be separated in 2 categories. The first would be persons who discovered vulnerabilities as part of their job function. And the second, a person who, without the knowledge or authority of the owner, broke into the internet-facing resources. The first category would be indemnified by the terms of their employment, and there is no penalty for same under the Act. On the other hand, where acknowledgement and approval were not gained from the owner of the resources, even if the person or persons were legitimately carrying out security research against resources, they would be guilty of an offense. Therefore, the Act does not criminalize white hacking or security research done within a structured framework with the necessary approvals. Your committee recommends that no amendment is necessary for the definition. We move on to part 2 that speak to offenses. Section 3, unauthorized access to computer program or data. Some members of your committee expressed support for the recommendation of one stakeholder that a framework be provided in the Act to recognize ethical hackers, and that Standard 7 of the Data Protection Act 2020 be considered. Is that Standard 7 or Section 7? We were advised that accessing a computer system without authorization would threaten the integrity of a computer system by either altering, stealing, or browsing the confidentiality of the system. Therefore, the criminalization of illegal access represented an important deterrent to many other subsequent acts against confidentiality, integrity, and the availability of computer systems. After careful consideration, we support the advice of the MSET that to access a computer system without authorization would be tantamount to accessing private property. However, we're of the view that policy options around the broader concept of ethical hacking, which would include gray hat hackers, persons who genuinely search networks to determine vulnerability and raise him, be examined. The MSET advised your committee that Standard 7, which is found in Section 30 of the Data Protection Act 2020, provides that the appropriate technical and organizational measures shall be taken by a data controller against unauthorized or unlawful processing and accidental loss or destruction of damage to personal data. It further provides that measures should be taken to ensure that Information Commissioner is notified without undue delay of a breach of the data controller security measures which might affect personal data. Also, the standard provides guidance on the types of technical and organizational measures that would be taken and the requirements that must be met where processing is carried out by a data processor on behalf of a data controller. Members of your committee were advised that Section 45 of the Data Protection Act 2020 places an obligation on a data controller to annually submit a data protection impact assessment outlining, among other things, the measures envisaged to address risks, including safeguards, security measures, and the mechanisms to ensure the protection of personal data and to demonstrate compliance with the Data Protection Act 2020. It was noted that Section 30, subsection 8A of the Data Protection Act 2020 is limited in nature and provides a defense in instances where a person willfully and without lawful authority breached any pseudonymization. We could have found a synonym for that. Or encryption applied to any personal data, which was specific in the defense of public interest. It was noted that whilst there was no formal arrangement outlined in any legislation for reporting the vulnerability of a computer system, reporting could be done through JCERT. It was noted that JCERT would ensure that the messages are delivered through a third party to the owners of a network for the necessary actions to be taken to mitigate challenges identified. Your committee recommends that no amendment is necessary for this section. We move now to Section 4, access to the intent to commit or facilitate commission of offense. it was recommended that section 4.1 be amended to state that persons commit an offense if he or she access or cause to be accessed any program or data. It was revealed that the intention of the proposed amendment was to ensure that the provision captured a person who did not directly access any program or data held in a computer, but facilitated the access by a third party. The MSED team informed your committee that section 12 of the legislation treats with the matter of inciting and conspiring with other persons to commit an offense under the Act, and did not see the need to amend the provision to take into consideration the recommendation. The committee sought clarification on the recommendation based on concerns raised at the meeting held on February 17, 2022. The MSED sent an email to the FSC seeking clarification on the matter. The entity provided the clarification in an email dated February 24, 2022, which was forwarded to members on February 12, 2022. No further discussions were held on the matter, and a decision is to be made. One stakeholder expressed the view that the section should be amended to provide for harsher penalties where the offense relates to a child, and the penalties under section
Chairman,
4. Yes.
Senator Gale, before you go on, Chairman, just for the intervention of the committee right here, if for the paragraph on the first paragraph on the section 4, is it the committee's intention to leave the section and as is? Because I realize that the committee didn't make a decision based on the recommendation that was made by the FSC.
So that's where it would have stated no further discussions were held on the matter and a decision is to be made.
Yes.
I think we should try and fill that gap there now, rather than having to come back to it. Member Gale, what do you think?
I think so too. But maybe that email that was sent with the clarification would assist us.
All right, so sought clarification on the recommendation based on concerns raised at the meeting held on February. So MSED was sent an email to FSC seeking clarification on the matter. All right, so what you're saying is that FSC has not responded to that email.
The entity provided the clarification in an email dated February 24th, 2022, which was forwarded to members on February 12th. So we would need to, first of all, jog our memories in terms of what is contained in that email to inform a decision.
So let me ask Ms. Campbell if you can, Ms. Brandon, can you resend out that email, those emails? So rather than delay, member, what I would suggest is that we just make sure that we have this on the agenda at the beginning of the next meeting and just
at the next meeting. Yes, Chair.
At the beginning, so that everybody has opportunity to just refresh themselves in relation to what the response from the FSC was, and we take a decision. Thank you, Ms. Brandon, for that.
So I will continue, Chair.
Yeah, make a note of that, Ms. Brandon, for me, please, for the agenda.
Noted, Chairman.
Go ahead.
Continue.
Yeah.
One stakeholder expressed the view that the section should be amended to provide for harsher penalties where the offense relates to a child, and the penalties under section 4 and 5 of the Child Pornography Prevention Act should be considered. It was further recommended that since cybercrime and child pornography were incorporated separately in the same legislation in other jurisdictions, the Act should be merged with the Child Pornography Prevention Act, as there were similarities with the provisions of both legislations. We support the suggestion that there should be harsher penalties in relation to offenses against children, and that there should be a distinction between the penalties for offenses committed against children by children and adult offenders. We further support the recommendation that the term of imprisonment be ranged from 15 to 20 years for an adult who commits an act where the victim is a child. We were informed that an obligatory international agreement was fulfilled when the Child Pornography Prevention Act was enacted, and that a merger of the Act with the Child Pornography Prevention Act would require policy direction. Your committee recommends that no amendment is necessary for this section. Section 5, on unauthorized modification of computer program or data. Your committee recommends that no amendment is necessary for this section. Under Section 6, unauthorized interception of computer function or service. Your committee recommends that no amendment is necessary for this section. Under Section 7, unauthorized obstruction of operation of computer. Your committee recommends that no amendment is necessary for this section. Section 8, computer-related fraud or forgery. It was recommended by one stakeholder that consideration be given to the introduction of an offense or category of offenses that treat with the possession, creation, and reproduction of electronic copies of forged documents. We're advised that the forgery of certain documents was considered a felony and attracted custodial sentences for a term of 7 years up to life imprisonment. And other documents, if forged, were considered a misdemeanor and attracted a penalty of imprisonment for a term not exceeding 2 years. Your committee, having learned that the Forgery Act is technology neutral and treats with certain types of forged documents, recommends that amendments be made to the legislation to take into consideration the creation of an offense generally relating to the possession of forged documents with the intent to defraud or deceive. Under Section 9, use of computer for malicious communication. One recommendation that was made by your committee was the inclusion of hate speech as a type of communication deserving of punitive treatment. Your committee was divided on whether the matter of hate speech should be included in the Act. One member felt that hate speech should not be included at this time because of the varied views of religion, sexuality, and ethnicity. Another member supported the inclusion of hate speech because a provision for same would provide the court with the ability to make a determination in particular cases on hate speech. Your committee was advised that the issue was a question of proportionality between freedom of rights and expression and deformity offenses, and there was no disagreement in the principle on hate speech. We're further advised by the LRD that the issue of hate speech engaged several rights under the Constitution, especially the freedom of expression. It was suggested that the ministry with responsibility for information should take the lead in crafting provisions on the offense of hate speech. The LRD's team agreed that the proposal that revenge porn or the sharing of an intimate image deserve a special treatment under the Act. We're informed that some jurisdictions addressed the proposed offense in a technologically neutral way, whereby the form of publication was not limited to computers. It was suggested that the proposal should include in a new Section 9 because it was sufficiently wide in scope as the provisions address data published with an intention to harass or cause harm. Based on the meeting held on March 22nd, 2023, the ODPP suggested that further consideration be given to the proposed new Section 9, since subsection 1 would allow for any type of data sent commenting on a person in an unfavorable manner to attract a criminal penalty. It was suggested that the list of categories of data that was being considered could be mentioned. We recommend that a new Section 9 be inserted along the following lines. 1, a person commits an offense if the person uses a computer to publish data to or in respect to another person with the intention that the data harasses the person or causes harm, or the apprehension of harm that the person or that person's property. For the avoidance of doubt, nothing in this section shall be construed as applying to any communication relating to industrial action in the course of an industrial dispute within the meaning of the Labor Relation and Industrial Dispute Act. At least one person would be happy of that. 2, in determining whether the data would cause harm, the court may take into account any factors it considers relevant, including A, the context in which data was sent, B, the characteristics of the recipient of the data, such as age, sex, or relationship to the sender of the data. C, the content of the data. D, the frequency with which the data was published. E, the extent of circulation, publication of the data. And it says that decision to be made by the committee regarding the words in bracket. Do we want to sort that out now, Chair?
Sure, why not? Member Gill?
I'm trying to find out, Chair. How do we determine the extent of circulation? I would need some guidance from the technical team, sir.
LRD or SG, you have any comments on that? Any guidance?
And so we're talking about the word publication.
As it's supposed to be defined in the provision, or based on what you're reading here now? Well, my understanding was that based on the concerns that we had, the DPP had expressed, and as we had shared that further discussions with them, we weren't able to resolve their concerns about the breadth of this proposed redraft, that we were now recommending that this proposed redraft, which you are reading, would not be proposed, but rather that the section would be amended. So I think this section of the report would need to be updated to reflect the discussions of today.
Right.
Or you want to treat that, Member Gill?
Based on the discussions that we had, I recall, so this was a section based on what the DPP was saying, would have required a review.
Right, and that was the review that we I'd mentioned at the beginning of the meeting that we had
Right,
done
that we had discussed earlier.
at the technical team, right? And based on that discussion, we shared with them the research that was done behind this proposed section, and there didn't seem to be a way to salvage it. They thought it was too wide. You would need to introduce qualifying words, which would bring us back to the position that we are already in the existing legislation. So it was thought better to just amend that section as opposed to doing a redraft. And I believe that the members had agreed on what those amendments would be. So I think this section of the report would need to be amended to remove this proposed redraft as being an action that the committees recommended.
And so that would take us to write down, the amendment would cover right down before leading to the section 10. It would take into consideration all this entire section.
Yeah, because that would be taken, right, because this proposal was being made to address a number of concerns that were being made by stakeholders, not just the DPP. But since it was thought to be too wide and you would need to introduce qualifying words, then it doesn't make sense to any longer propose that it's redrafted in this way. It would just make more sense to amend the section, as was said. So I think, as I was saying before, that we would need to edit the report so that for section 9, at least, it reflects the discussions of today. I don't know if it should say that this was considered, but is no longer being considered, or what it should say.
So two things would happen, Chair. We await what the possible redraft would be, and then the next draft of the report before the next meeting would include what would constitute this particular area of section 9.
Members, any comments on that? All right.
So I can now move on to section 10.
Sure.
Section 10, unlawfully making available devices or data for commission of offense. We endorse MSET's proposal that the section be amended to bring it in line with the convention by providing that an offense is committed if a person without unlawful justification intentionally, 1, manufactures, sells, imports, distributes, discloses, or otherwise make available A, a computer, B, any key, or C, any other data or device that is designed to adopt primarily for the purpose of committing an offense under any of section 3 to 9, or 2, receives or possesses an item mentioned in subparagraph A, B, or C with the intent that it be used by any person for the purpose of committing an offense under any of sections 3 to 9. Section 11, offenses relating to protected computers. We accept the recommendation of one stakeholder that the section be amended to include protected computer systems that are necessary for or used directly in connection with revenue services. We recommend that the word medical in section 11, subsection 2E be changed to the word health, as we believe that the term is broader to cover all health systems. Section 12, inciting. Your committee recommends that no amendment is necessary for this section. Section 13, offenses prejudicing investigation. One stakeholder noted that the burden of proof seemed to be on the person against whom the charge was laid. The stakeholder stated that the level of evidence required to ground an offense of this nature should meet the standard for criminal liability and should not shift the burden of proof on the person being accused to prove his innocence. The AGC advised that there was an arguable basis to conclude that section 13 of the Act imposes a burden on the accused to establish a defense, but the burden arises if the prosecution successfully establishes the core features of the offense. It was further noted that placing the burden on the accused was legally permissible if reasonably imposed and proportionate. We're advised that Section 13 of the Act was introduced to mirror provisions of the Proceeds of Crime Act after consideration and recommendation by the Joint Select Committee that reviewed the Cybercrimes Act 2010. As such, the AGC expressed the view that Section 13 of the Act was reasonably imposed, proportionate, and was legally permissible. Your committee recommends that no amendment is necessary for this section. Section 14, offenses by bodies corporate. One stakeholder indicated that the Act imposed strict liability on certain officers. It was suggested that specific liability be imposed when an employee used a company's computer or data storage medium for personal use. And liability should not be created for a company that is and its officers. It was further suggested that due diligence required of a corporation should be clear to ensure the liability will not be attached to certain officers in such cases. The LRD advised members of your committee that if an employee went on a frolic of his own, the employee would be prosecuted similarly to any other individual who commits an offense. With regard to the issue of due diligence, it was noted that this requirement was not spelled out in the relevant company law and was left out to ensure that officers continue to adapt to the risk of a company. Your committee recommends that no amendment is necessary for this section. Section 15, compensation. In considering the recommendation of one stakeholder that the section should be more definitive to allow compensation to be ordered as a matter of course, not only as at the discretion of the court or on the application of the complainant. We recommend that the provision be amended to carve out a regime similar to Section 24A of the Criminal Justice Administration Amendment Act of 2018. We now move on to Part 3, investigations. Section 16, interpretation and scope of Part 3. One stakeholder noted that notwithstanding Section 16(1)(b)(2), the Act has not provided law enforcement agencies with a mechanism on how they may seek to legitimately render data inaccessible or remove it from a device. The stakeholder pointed out that where part of the evidence relied on by the Crown, including material obtained from a device, law enforcement agencies would be obliged to return the device and any property seized during the course of prosecution upon acquittal of the person. The stakeholder also expressed the view that there was no power available to law enforcement agencies to allow them to permanently erase offending material from the device prior to its return. It therefore recommended to your committee that the categories of data which were sufficiently comprehensive should be identified or defined that ought to be sanctioned. We note from the AGC's advice that Section 16(1)(b) describes 3 categories of actions to be carried out in order to exercise the power to seize, but does not include the mechanism to guide law enforcement on how to carry out the power to seize. We further noted that the method by which seizure was effected would be left to a constable who executed a warrant subject to any details in the warrant issued by a judge of a parish court. Therefore, the AGC pointed out that the Act leaves the mechanism for executing seizure powers to the administrative policies of the law enforcement. In respect of erasing offending material from a device, your committee was advised that Section 20 allows for the forfeiture of computer material in 2 circumstances. Firstly, as outlined in Section 2, subsection 2, where a person had been convicted of an offense, among other things. Secondly, as determined by section 20, subsection 3 and 4, where a parish court judge or a judge of the Supreme Court in Chambers may order the forfeiture of computer material where the requirements in section 20, subsection 2 have not been satisfied. The Act therefore provides a mechanism for the forfeiture of seized computer material outside of a criminal conviction. And so your committee recommends that no amendment is necessary for this section. Section 17, preservation of data. Your committee recommends that no amendment is necessary for this section. Section 18, search and seizure warrants. We question that if the section covers situations where the police inadvertently or criminally allowed proprietary data from a company whose machine has been seized to be released. The AGC advised members of your committee that as a general principle, in situations where there was a loss to an entity or the person whose information was unlawfully disclosed, the laws in Jamaica provided a mechanism for persons to seek compensation where it had been established that the victim suffered loss. Your committee recommends that no amendment is necessary for this section. And under section 19, record of seized material. One stakeholder raised concern regarding the time for the execution of warrants for material that were seized and pointed out that the term "as soon as possible" was too wide. Research done by the MSET revealed that there was no national legislation that specified a timeline for the inventorying or of seized material, and other legislation took a similar formulation as the provisions in the Act. Based on consultation with MOCA, it was noted that there need to be latitude to allow law enforcement officers to prepare a list of items seized or rendered inaccessible. We took note of the fact that law enforcement officers' compilation of a list of items seized depended on a number of factors to include the size of the data seized and whether the data was in intelligible form. In order to treat the issues relating to the way in which law enforcement agencies carried out their investigations, we learned that it might be useful to amend the legislation to include a provision that standard operating procedures be developed and observed in carrying out these investigations. We further recommended that the SOPs should be placed either in the primary or secondary legislation as part of investigative procedures if there were merely specific guidelines on matters such as the time frame within which entities should act. Section 20, forfeiture.
Senator Gill,
Yeah.
Before you go, members, right here, I was a bit confused as to the recommendation of the committee, and I have placed the recommendation in red. So if you could just provide further clarity on what the committee's recommendation is, because the committee, from the meeting that we had on this section, was recommending that SOPs be placed either in primary or secondary legislation. I wasn't so clear on this.
You're saying it has to be one or the other, primary or secondary? LRD, what is the clarification you're seeking? Whether or not it is primary or secondary legislation?
Yes, Chairman, because the primary legislation would be the Act itself. And I'm not certain whether or not there is a secondary legislation governing the Act. So I would need clarification on this, Chair.
You're saying that it should be primary and take out our secondary.
It's Chesney Brandon from Parliament, Chair. So it's just for my clarity.
Oh, for your clarity.
Yes,
Yeah.
Chair.
Chair,
LRD?
if I might assist here, Judith Grant, I don't think, Ms. Brandon, that a decision needs to be taken. The report could specify primary or secondary because it would have to be determined based on what is being contemplated, whether it's best placed in primary or secondary. So the recommendation need not specify which.
Noted,
In
Ms.
other
Grant.
words, it's fine as it is, yes.
So this is in fact what the committee would be saying,
Yes.
stating in the report, but not that a decision ought to be made.
That's correct.
Oh. All right, so that being said, Chairman, I can continue.
Sure.
Moving to section 20, forfeiture. The Act empowers the Director of Public Prosecutions to apply for a forfeiture order and sets out the criteria that must be satisfied by a parish court judge or a judge of the Supreme Court in order to make a forfeiture order. One stakeholder suggested that the category of officers who could make a forfeiture application should be extended to include clerks of court. The ODPP advised that an anomaly was created in respect to section 20 subsection 2, in that the ODPP had to intervene post-conviction for forfeiture applications if a conviction were made in the parish court. We learned that section 24 subsection 2 of the Dangerous Drugs Act and section 20A of the Quarries Control Act empower the prosecution to apply for the forfeiture of the instruments of a crime. It was suggested that an amendment be made to the provision of the Act, similar to these legislation, to make reference to the prosecution instead of the Director of Public Prosecutions. We're advised that the reference would enable either a prosecutor in the High Court acting under the authority of the DPP or clerks of court in a parish court to apply for the post-conviction forfeiture. It was suggested that only the DPP should have the authority to apply for forfeiture at the parish court or the High Court, since there would be more serious consideration for the forfeiture of items that were not the subject of a conviction. We endorse the suggestions made by the Office of Director of Public Prosecution. Section 21 to 28, the committee recommends that no amendments are necessary for sections 21 to 28. Other recommendations. Stakeholders raised general concerns and made recommendations that were considered by your committee, and we are pleased to report on the following. 1, disclosure of a key for protected computer to an unauthorized person, authorized disclosure or of password or access code, and unlawful divulging of information. It was recommended that the mere act of disclosing a key should be an offense, but in respect of protective computers, it should be immaterial whether this disclosure could be proven to have been made for the purposes of committing or facilitating the commission of an offense. It was further recommended that a provision be included which makes it an offense to disclose a key in respect of a protected computer to a person who was not authorized to receive the key. Additionally, another stakeholder proposed that unauthorized disclosure of a password or access code and unlawful divulging of information should be offenses addressed in the Act. Based on research done by the LRD, it was noted that all jurisdictions but one, mere disclosure was not an offense, but must be for the purposes of a wrongful gain, an unlawful purpose to occasion any loss or with the knowledge that disclosure was likely to cause prejudice to any person. your committee noted that it would be unusual for the proposed amendments to be made to the Act. Your committee learned that if considerations were given to amending the Act so that the mere disclosure of a password and an access code or other means of access to a protected computer was an offense, then provisions would need to be made so that a person who lawfully disclosed a password would not be liable for prosecution by virtue of this provision. We were advised that consideration could be given to amending Section 10 of the Act so that, in addition to the offense being committed in order to further the commission of another offense, it would be committed in the alternative if the offense was committed for the purposes of any wrongful gain, any unlawful purpose, other than the furtherance of a commission of an offense, to occasion any loss, or with the knowledge that the disclosure was likely to cause prejudice to any person. So your committee does not recommend that the proposal be adopted. 2, use of premises, etc. We agree that the language similar Section 5 of the Law Reform Fraudulent Transaction Special Provisions Act be considered for the offense of use of premises, etc. 3, cyber stalking. 2 stakeholders recommended that a provision be inserted in the Act to provide for cyber stalking. One of the stakeholders suggested that the offense should particularly be in respect of cyber stalking of a child. The LRD informed members of the committee that in most of the jurisdiction it reviewed, except for Ghana, cyber stalking was usually dealt with within provisions relating to malicious communications, which is found in Section 9 of the Act. In light of the information provided, it was recommended to your committee that there was no need to amend the Act to consider the proposed offense. Additionally, the LID recommended to your committee that the issue of cyber stalking should be dealt with in keeping with the recommendations of the Joint Select Committee that reported on the Cybercrimes Act 2010, and the Joint Select Committee that reviewed the Sexual Offences Act, along with the Offences Against the Persons Act, the Domestic Violence Act, and the Child Care and Protection Act. It was pointed out that the LRD prepared a policy paper dealing with stalking as an offense, and it made recommendations to the Ministry of Justice on the legislative options that were available in creating an offense of stalking, whether by way of enacting of a separate legislation or as an amendment to the Offences Against Persons Act and other laws that were likely to be impacted by the creation of the offense of stalking. And so based on the meeting held on May 26, 2022, the committee did not make a decision on the same. Want to determine that now, Chair?
Yes, member, for sure. Member Gill?
Yeah, I'm just trying to recap in my mind. Can I make a suggestion? So I would ask members for us to make a review of these areas that requires a decision and reflect upon it, and at the next meeting we go through and make decisions in these particular areas rather than off the cuff.
Yeah, probably the easiest. What I would ask Ms. Brandon to do is just to highlight them for the next meeting, so that we can just go through and tick them off.
So we move on to 4, sir. Making false publication. We agree with the recommendation that the ministry responsibility for information should review the policy regarding false publication and fake news, and there should be consultation with the necessary stakeholders for the right approach to be adopted regarding the way in which these matters are addressed. 5, cyber squatting, cloning. Having been advised that it was not necessary to accept a recommendation made by one of the stakeholders that an offense provision be created for cyber squatting, as section 5 to 8 of the Act address the issues. We, however, agree with the suggestion proposed by the LRD that Jamaica subscribes to the World Intellectual Property Organization's dispute resolution services. It was noted that the WIPO arbitration and the mediation center deals with domain name disputes without the need for litigation. 6, cyber defamation. Whilst we noted that in one of the submissions, the suggestion that provisions be made in the Act to treat with the cyber defamation, we are recommending that consideration be given to the establishment of a joint select committee to review the Defamation Act 2013. 7, cyber threat. We recommend that the ministries with responsibility for the Towns and Communities Act and the Offences Against Persons Act should make amendments to the respective legislation to treat with the issue of threats generally, or which cyber threat would be a subset. 8, dissemination of obscene materials. One stakeholder suggested that the dissemination of obscene material should be an offense in the Act. We're advised that the Obscene Publication Suppression Act and the Child Pornography Prevention Act would address the offense, and the Act would apply if a computer or computer network was used to commit an offense under both legislation. However, we took note that the monetary penalty and the term of imprisonment in the Obscene Publication Suppressions Act were low and needed to be updated. The LRD advised that since the legislation was passed prior to the Constitution, it was saved from constitutional challenge on the basis of potential infringement on the right of freedom of expression, and any amendment would remove this right. We therefore recommend that the legislation be repealed and replaced in keeping with the Charter of Fundamental Rights and Freedoms. We're of the view that this would ensure that data and material published or distributed as a result of advancements in technology would be captured. 9, illegal selling/trafficking, cyber-enabled crime. We note comments provided by a stakeholder that the internet paved the way for the sale of illegal materials and trafficking, and that these forms of trafficking went unchecked because they were carried out under pseudonyms. Whilst there were no proposals made regarding the matter, members of your committee were advised that the Dangerous Drugs Act and the Firearms Act would prosecute offenses relating to narcotics and weapons. Based on the language used in both legislations and Section 4 of the Act, if cyberspace were used to commit an offense, it would be prosecuted as a cybercrime. 10, identity theft and data theft. Comments regarding identity and data theft were noted by your committee. In respect of identity theft, we noted that there was no provision in the Act to address same, but the matter was addressed in Section 10 of the Law Reform Fraudulent Transactions Special Provisions Act. With regard to data theft, Section 3, 5, and 7 of the Act would adequately cover the issue, and Section 61 of the Data Protection Act 2020 would cover the issue of personal data. Members were advised that depending on the circumstance, data theft should be classified as an unauthorized modification of a computer program or data under Section 5, or the unauthorized obstruction of the operation of a computer under Section 7 of the Act. Move on to Section 11, net/cyber extortion.
Chair, or Senator Gale?
Yes.
Sorry.
Okay.
Yes, I'm going back to number 8. Dissemination of obscene materials. I see in bold, we therefore recommend that the legislation be repealed. This suggests that this committee is making this recommendation. Am I correct? That you're recommending the repeal and replacement of the Obscene Publications Act? Is that what is being, is that the intention here? And was this a recommendation of the, I would suggest the use of a language. This is not the obscene, I spoke about this a little earlier. The Obscene Publications Act does not fall under the remit of MSET. So yes, it is true that sometimes a joint select committee can look at another law that doesn't fall under the remit and its jurisdiction and make certain recommendations, but there is an added nuance that this is something that has received a special protection, a savings protection under the Constitution of Jamaica, and that savings protection is the current policy of the government of Jamaica. I would therefore ask the committee to reconsider the language used in number 8 and the recommendation. If the committee really is so minded, then perhaps you could ask for some consideration to be given to reviewing the Obscene Publications Suppression of Act. But I would ask you to really reconsider what is here in bold as a recommendation of the committee in light of what I've just said.
So what you would be suggesting is asking for a review instead of a repeal and replacing?
Yes, taking into account a number of factors. 1, it's not MSET's legislation. 2, has received special protection under the Charter of Rights from challenge. That was a specific decision made by the Parliament when they did a recent amendment. Well, we still call it a recent amendment, the 2011-2012 amendment to Chapter 3 of the Constitution. It's my understanding it is still the current policy of the government of Jamaica. In light of what I've just said, I really do believe the committee should give further consideration to the recommendation being made in number 8.
We are guided by you as we were before, SG. So remember, I think that should be taken on board.
Accepted, Chair. So we move on to, we're at 11. Net cyber extortion. A stakeholder defined net extortion as the copying of an individual's or a company's confidential data in order to extort the said company of a large sum of money. Members of your committee questioned if the provisions that existed under normal extortion would be applicable to extortion done in cyberspace, and whether a separate provision would be necessary for same. We're advised by the LRD that the existing provision for extortion were adequate, and Section 4 of the Act would address same if it were done in cyberspace. There were 2 approaches that were generally taken in relation to cyber extortion. That is, provision for the specific offense in the Act, or the reliance on the general provisions relating to extortion. It was noted that most jurisdictions have adopted the latter approach. We're advised that since the provision was already made for extortion, there was no need to make provisions for a specific offense on cyber extortion. 12, webjacking. Your committee noted that there was no need to make specific provisions for webjacking since the existing provisions of the Act adequately address the issue. Specifically, the offenses of unauthorized access, unauthorized obstruction if a person was no longer able to control a website, or possibly unauthorized modification of a computer program or data. 13, cyberbullying. It was noted, it was pointed out by stakeholders that there appeared to be a gap in the Act and the Child Pornography Prevention Act 2009 because they did not address the issue of cyberbullying. We're advised by the LRD that depending on the conduct, cyberbullying could be prosecuted as malicious communication. But the difficulty anticipated was the requirement that if it be proven that the communication was obscene, constituted a threat, or was menacing in nature. We noted that the revised Section 9 focused on the harm of such communication rather than the nature of the same. Given that cyberbullying takes place among school children, we suggest that the Ministry with Responsibility for Education Act consider making amendments to the legislation and its regulations similar to the Ontario Education Act on bullying in general and cyberbullying in particular. It is being proposed that instead of criminal actions, that disciplinary measures be taken to address the issue of bullying along with the necessary remedy to address the injury. 14, Fingerprints Act. We support the recommendation of one stakeholder that where a person is charged for a cybercrime offense and or where he or she is convicted, the fingerprints of the person should be taken and stored by the Criminal Records Office in accordance with the Fingerprints Act. Your committee therefore recommends that the Ministry with Responsibility for Fingerprints Act urgently considers amending the second schedule of the legislation to include all offenses under Cybercrimes Act. Chair, I note here the reference to he or she, but previously we would have referred to his singularly as male. I think somewhere along the line we're suggesting to be consistent. Just for thought. (15) Cybercrimes Act, Law Reform, Fraudulent Transactions, Special Provisions Act. Your committee noted the recommendation that the Law Reform, Fraudulent Transactions, Special Provisions Act and the Act be amended simultaneously, and the comment that a criminal action could be an offense in both acts. We suggest that the Ministry with Responsibility for Law Reform, Fraudulent Transaction, Special Provisions Act engage the process for the review of same. 16, the Sexual Offences Act. It was recommended that by one stakeholder that Section 8 of the Sexual Offences Act be amended or the Act be revised to include a provision that was akin to Section 63 of the Ghanaian Cybersecurity Act 2020. We do not support this recommendation as we were advised that Section 4 of the Act already addresses the concern and that the proposals of a joint select committee that reviewed the Sexual Offences Act along with the Offense Against the Person Act, the Domestic Violence Act, and the Child Care and Protection Act in its report seem to be closely related. We recommend that the relevant ministries have consultation on the proposed provision. 17, aiding and abetting of a child dealing for the purpose of sexual abuse. One stakeholder recommended that Section 9 of the Sexual Offences Act be amended to include the same level of specificity as Section 64 of Ghana's Cybersecurity Act 2020. We support the advice provided by the LRD that the stakeholder should consult the Ministry of Justice regarding enlarging the offense in Section 9 of the Sexual Offense Act. Additionally, it was pointed out by the LRD that based on the elements of the offense in Section 64 of Ghana's legislation, it was realized that there had been a trend internationally towards regulating online content providers and internet service providers so that they play a more proactive role in monitoring contents uploaded on their systems and provided opportunities to have persons remove the contents where they have been uploaded. It was pointed out that the Joint Select Committee that reviewed the Sexual Offences Act, along with the Offences Against the Persons Act, the Domestic Violence Act, and the Child Care and Protection Act, in considering Section 9, Sexual Offense Act, recommended an adequate safeguard in terms of broadening the means of communication with children and broadening the scope of the offense to include persons. The LRD further advised that if it were accepted that Jamaica should move towards regulating online services providers and social media, there would need to be a discussion with the Ministry of Justice along with MSET, since the Telecommunications Act might be impacted. We support this advice. 18, skimmers / card readers. One entity made presentation to your committee suggested that possession of skimmers and card readers without lawful excuse should be an offense. We were informed by MSET that the Customs Import Prohibition Miscellaneous Goods number 2 order of 2010 specifies the different types of paraphernalia that would not be imported without meeting the conditions that were stipulated. Members of your committee were advised that credit card scamming equipment could not be imported in Jamaica unless there was an import license or permit or prior approval was sought from the minister with responsibility for national security. We noted that unlawful possession of credit cards, skimmers, would be an offense in the redraft Section 10 of the Act. And if other paraphernalia, such as magnetic strips and point-of-sale devices, were to be considered, it was recommended that the Ministry with responsibility for the Customs Act have the order expanded to include the additional items. We support this recommendation. 19 speaks to intentionally withholding message delivered erroneously. Members of your committee was informed by the Ministry of National Security that victims were frequently subject to scams and fraud schemes and have made genuine mistakes, sending messages as well as making payments to unintended recipients. We were advised that the Act currently does not allow for the prosecution of offenders who deliberately refused to cooperate with such instances, which would leave a victim to pursue a civil lawsuit. It was noted that Section 61 of the Data Protection Act 2020 makes provision for personal data sent in error, and if the unintended recipient of the data actually used same to procure advantage for himself or herself, the person would be liable for fraud under Section 8 of the Act. In respect of erroneous payment, your committee recommends that the Ministry of National Security recommends to the Ministry of Justice, after consultation with stakeholders, such as the financial institutions, a possible amendment to the Larceny Act to create an offense similar to the Theft Act 1968 of the United Kingdom that addresses the issue of dishonestly retaining a wrongful credit and the inclusion of a provision to address payments made in error. 20, educational program. Your committee supports a proposal made by the governmental entities such as the ODPP, the Jamaica Constabulary Force, the Financial Investigation Division, and all investigating agencies such as the Jamaica Defense Force, military intelligence, take a joint approach to take an effective educational program, or to have an effective educational program to allow them to be versed on the provisions of the Act in order to detect, investigate, and prosecute offenses under the Act. 21, cybersecurity legislation. We noted during our deliberations that some of the general concerns raised by stakeholders would be best addressed in cybersecurity legislation, such as the protection of critical systems, standards, and guidelines for accessors of cyber services of protected systems, and the establishment of a cybersecurity authority. It was noted by one stakeholder that there should be guidelines and standards for the protection of protected computers. Organizations with protected computers should be certified against standards, and vendors offering security services to entities with protected computers should be licensed. We were informed that the National Cybersecurity Strategy 2015 recognizes the need for establishment of standards and guidelines, the development of National Cybersecurity Directorate, the development and adoption of cybersecurity technical guidelines for micro, small, and medium-term enterprises, the strengthening of incident reporting and response, and the strengthening of partnership and cooperation. Members were advised that the Information and Communications Technology Authority Act 2019 establishes and authorizes a statutory body with responsibility for guiding the ICT affairs of public entities, as well as recognizes the need for the ICT authority to establish standards and guidelines that public entities were required to adhere to in relation to their IT systems and security. Additionally, the Data Protection Act 2020 recognizes the need for the establishment of standards and guidelines. Notwithstanding these provisions, we are of the view that cybersecurity legislation may be necessary for the protected computers in the private sector to conform to minimum standards and guidelines, certification, and the licensing of vendors offering security service to private entities. However, the promulgation of cybersecurity legislation would require consultation with stakeholders and cabinet's approval. We recommend that consideration be given to same. 22, responsible disclosure. Whilst one stakeholder addressed that a vulnerability disclosure framework be developed to allow individuals to report potential vulnerabilities without the threat of legal action, we were advised that JCERT facilitates the reporting of issues through its website and that the report should be anonymized. It was explained to us that there would be no threat of illegal action, and where vulnerability was verified, contact would be made to the owner of the IT resource, and a joint effort would be made in respect of mitigation and or remediation. One member of your committee suggests that work be done to promote the present framework that operates through JCERT, whilst fast-tracking a more formalized framework in accordance to the European Union or other best practices across the world to ensure that an open framework that applies to the public and private sectors. 23, protection of wireless network. It was recommended that wireless networks should be protected by mandating that they be passwords protected as a mitigating measure against cybercrime activities. Your committee learned that the policy objective of the government was to ensure access to the populace to the internet, of the populace to the internet. We support the recommendation that cybersecurity and data protection issues that may arise as a result of accessing public Wi-Fi be addressed in public education campaigns. We also support the view that entities that provide access to open Wi-Fi be encouraged to establish privacy and security statements relating to the use of their service. 24, legislative sandbox. It was recommended to your committee that consideration be given to the granting of exemptions on open license in the context of academic freedom to conduct cross-border exchange regarding teaching and research through the creation of a sandbox. JSERT defined as regulatory sandbox as a contained environment in which regulated entities may test their products, services, or solutions subject to the requirements under the subject framework. We were informed of two types of sandboxes, that is, regulatory and industry sandboxes, which were developed by regulators and businesses respectively. We took note of FinTech Sandbox in Jamaica, which was operated by the Bank of Jamaica and came about as part of the Payment, Clearing and Settlement Act of 2020. JSERT pointed out to your committee that the establishment of a sandbox would be treated through policies within a sector rather than generalized government approach and a framework be written into law. We were advised that while sandboxes provides a scope for innovation and testing of products at the pre-production and production levels before release, there was no supporting evidence through the research conducted where there was a generalized sandbox written into law. We're of the view that a generalized sandbox could be explored in the near future, given that the country currently did not have a regulatory framework for its creation or an entity designated as a regulator. And 5, your committee wishes to express its gratitude to the entities that made oral and written contributions on the act. Special thanks are also extended to the technical team from the MSEC, the OPC, the AGC, and the LRD. Your committee wishes to express thanks to the media, which ably reported on the proceedings of the meeting. Your committee also wishes to thank the clerk and the staff of the Houses of Parliament for their support and courtesies extended during the proceedings. Chairman, here ended the reading. Time for some water.
I was wondering how long it would take you to take a breath. Very good, sir. Very good, very good. So members, thanks again to Member Gill, what started. Based on the findings and recommendations, we still have some outstanding matters that came up during in the document, which we're going to take at the next meeting, which, as I said before, is the 19th at 10 a.m. And I think since we're already over time, what I will do is just allow the members to give any final comments on what was presented today after we finalize on the 2 or 3 outstanding items that needs finalization. So with that, I would say that we have completed a good session of the Joint Select Committee. It's 12:18 now, we're a little bit over time. So we will resume on Wednesday the 19th at 10 a.m., which is next week. And as I said before, we will handle the outstanding matters to complete the findings and recommendations, and of course, any comments that the members would want to make at that point. So I think we have done good day's work. We had agreed that we would deal with the confirmation of the minutes and any matters arising. So can we just do that quickly? I wasn't present, so that somebody that was present, just move for the confirmation, and of course any matters arising.
All right, so move.
Moved by member Roland Campbell.
Yes, Chair.
Seconded
Second, Chair.
by member Cavan Gale. Any matters arising from the minutes? All right. So with that, at 12:20, we will adjourn to meet back Wednesday, the 19th of April at 10 a.m. And hopefully, if all goes well, that should be our last meeting. Congrats on that. Look forward to seeing you next week and to concluding this very important Joint Select Committee on the review of the Cybercrimes Act 2015. Until then, stay safe, and thanks everybody for their participation and of course the support staff. Thanks very much.
Remember that big project the government announced them was going to from when? You ever get yourself a wonder what happened to it? Stop wonder like an outsider and start move like the country belong to you. You have a right to publicly owned information, and the Access to Information Act gives you that power. I know you have enough questions about how government are run or not run, so let me show you how it works. Say mosquito spraying going on in your community, your children asthmatic and you want to know what chemicals are in it. Or what about that Auditor General report on a public official getting twice his salary with no proper approval? Is your taxes and you want to know if they paid it back? First, do some basic searching to see what is already on government websites. If you don't see what you're looking for, make a formal ATI request by completing the application form on the ATI site or sending a letter or email. And remember, you don't have to say why you need it. It is your right to know. Make sure you send your request to the right agency, and once they confirm receipt, they get 30 calendar days to provide the information, a maximum of 60 if extra time is needed. Yes, I know you want access to everything, but sensitive documents are protected from the public for up to 20 years. For example, documents that would expose a citizen's personal privacy, or those dealing with cabinet discussions, the Governor General's office, or information on the investigative activities of the security forces. Any public officer who tries to destroy or hide any official document can be sanctioned. And if you're having difficulties, the ATI unit will help. So, what if the chemicals in the mosquito spray are toxic? What if the agency did not even try to get back the money they paid out? Call or email your MP. Share the concern, because as your elected representative, they can represent your questions to the government ministers in the House. Remember, it is the job of parliamentarians to monitor and hold the government to account on your behalf. Is not every country gives citizens this kind of power, you know? And at 20 years we have this law, and we barely use it. So access information and mind your business, Jamaica. Visit jampja.org today to see what information we access to make it easier for you to hold the government to account. Let's do our job to make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union in partnership with the Private Sector Organization of Jamaica.
1, 2, 3, 2 more. 1, 2. Adults to 30 minutes activity daily. Love your body, treat your body right. Vegetables, make sure you eat plenty. Children do 60 minutes activity daily. Drink some water when you feel thirsty. Cut down dessert and have a smoothie. Jamaicans, love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. One more time now. Love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. Listen up. Make sure you know your health status. Go a doctor and get a regular checkup. Chronic disease can slowly creep up. We can lower the risk and live up if we just eat right and get moving. Jumping, running, dancing or skipping. Change the children, them lazy habit. Make them play out the door and put down the tablet. Jamaicans, love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. Jamaica get moving. Love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. After 2, make me hear you say I love me. 1, 2. 1, 2. 1, 2. After 2, make me hear you say I love me. 1, 2. 1, 2. 1, 2. Jamaicans, love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. One more time now. Love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. Jamaica get moving. Love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. One more time now. Love your body, treat your body right. Love your body, treat your body right. Just eat right. Love your body, treat your body right. Love your body, treat your body right. Listen up. Love your body, treat your body right. Love your body, treat your body right.
Whenever you hear the following tone, the Office of Disaster Preparedness and Emergency Management, ODPEM, will be giving information on an emergency situation affecting the island. Please be on the alert and listen to your radio and television for further information. This was a test of the emergency alert system, brought to you by ODPEM.
If ever there was a time to take care of your mental health, it is now.
Now, when your physical health so clearly impacts your emotional health.
Now, when we need to talk and listen to each other.
Now, when supporting each other means survival.
Now, in a time of COVID-19.
Speak up.
Speak now.
Beat COVID-19.
Call 888 New Life. 639-5433.
Jamaica is a beautiful place. Our people have a beautiful spirit, but we are too aggressive, and the way we interact with our friends and neighbors, I genuinely believe that we have the capacity to deal with this problem of violence. But it's going to take all of us. It's going to take every organized group of Jamaicans that we fundamentally reject violence. Violence has no place in a modern society.
We tend to see the smudge on someone else's mirror and forget the crack in ours. Start by fixing yourself first. Educate yourself.
Well, I guess I should start by saying I have roots in Montmartre, and the property that's going to be used to do the model farm, I guess, is my family's. I've had an interest, in agriculture. I was a Peace Corps volunteer, an agriculture Peace Corps volunteer in Sierra Leone. So I've always had an interest. I had a biology degree in plant biology. Growing up in Grenada, I guess I had an interest in agriculture because my father had this farm and there was cocoa and lots of vegetables and things like that. So there's always been an interest in agriculture. And I guess the opportunity with this project, the land was pretty dormant, I guess, just sitting there. So I thought, why not utilize it? I think my father would have wanted to be utilized. I don't think we wanted to sell at that point because it's what he lived his whole life around, wanting to see something come out of the land.
My name is Alfred Hines. I've been in agriculture my whole life. Even as a boy growing up, we used to have parents being agriculturists. You have, your goats to see about and your own small plot of land to cultivate and so on. So basically, I've been doing agriculture for a living since 1984.
My name is Nelson Hines, brother to Alfred Hines. I'm in agriculture since nature. Since nature. I'm there. My father and my mother was pure farmers. So I'm there since up to now.
My name is Denise Ogilvie, and I'm the CEO of People in Action, which is a local NGO here in Grenada. We focus in on socio-economic development for communities, mostly a ground-up strategy of how we might now enable communities to be empowered to understand their resources that they have available to them and how they might best work with them in a sustainable manner.
Immediately the community would benefit because it's within their backyard. But we're also looking at the national level where it's going to be a model farm where we're using the permaculture design. So farmers and other community members could come in and learn. It's going to be a research institute. They're going to learn what are the practices that are happening there, particularly permaculture design, and find ways to integrate these practices into their own local community or within their own farm. So it's really going to be an excellent learning institution for persons locally, nationally, and you never know, too, regionally too.
To start the project, we brought in the permaculture design team. They came from Trinidad. That was the Caribbean Permaculture Consultants. That is John Stallmeyer and Earl Nurhara Hammond. They have an example in Trinidad called the Wasamaki Ecosystem Farms, and it was their example that we saw in the beginning that gave us the courage and the inspiration to do something like this now.
We do, through the GIZ funded project, we have a collaboration with People in Action, which is a community-based organization. And government rules is diverse because as a Ministry of Agriculture, we have the site is a demonstration site. We never did a climate smart project before. So you use the demonstration site to help farmers understand the concept. Because I could say the definition of climate smart agriculture, at the end of the day, everybody say, okay, but what do you mean? You know, what is the operational plan? When they go to the site in Mount Morris, they could see, okay, climate smart agriculture means that if I am a farmer, this is what is required of me. That is one role. So a role of awareness about the concept of climate smart. Another role is that we are now in dialogue with the Ministry of Works to ensure that the access to that demonstration site is not only done in accordance with like normal construction standards, but that is also a green approach.
Well, I think that the project is dealing with climate smart agriculture. You know, trying to do agriculture in a climate friendly manner, which is what I believe in. You know, I don't believe in using too much chemicals and these sort of stuff. You know?
This is Zone 1. These are those places here. This is where your herb gardens and your small vegetables like lettuce, cabbage, they need shade and they need a lot of care and water. So we put them close to the buildings. These are the buildings where there'll be a lot of water coming and being used by animals and by humans here in the classroom here. Zone 2 will be that small tree area where we'll intercrop with things like provisions, your yams, your dashins, your tanyas, different things like that, sweet potato to cover the ground, things like that, ground provisions. Eddos, which here is very known for.
All included.
So your animals and as well as your fodder, which means we're going to put grasslands here as well on this border here. It's really important to grow your own feed.
One of the challenges I think will be that of getting people to buy into the project. You know, it's different. We are accustomed to using basically fertilizers all the time. I would say traditionally that's how we farm. Right? So this concept is a different one. You're working basically with the environment. So I think getting people to buy into the idea, understanding what it's all about, and making the transition. I think that will be a challenge, but hopefully with education we'd understand more and more. It's not just about yourself, but you have to think about the wider environment.
It's also important for the farmer himself to understand that he must also have a better management system. He has to do more recording of things. He must be more observant. So we've designed, or we are in the process of designing, a tool that will be able to capture data. We want to make sure that it is also friendly to the farmer, not just to the technocrat, so that maybe what he can say is, I started my, I planted the seeds for the tomatoes today. I know that these tomato seedlings will take X amount of time. I now have a little notifier coming up and telling me I am to look up my tomatoes to prepare those beds, because in a week time those will be ready to go down. But then the farmer can chalk and say, okay, I have planted tomatoes. MNIB can now know John James has planted tomatoes. They can now understand within 3 weeks' time, they can look towards John James to see if he has any produce and if he would be a supplier for them. They know where the next supply is coming from. It's these sort of things that this precision agriculture tool that we're designing will be able to track.
I have been involved as the researcher, basically developing the research methodology to collect the data in preparation for this project. We have employed a method which we call mapping. It is a participatory methodology that gets the community involved in the process, in the mapping process. So not only are the community members providing the information, but they're also providing the language that we use when we ask questions. They're providing information on the resources in the community. The community mapping basically is a tool for assessing the resources in the community, the physical resources, the human resources, the networking, both formal and informal. So it is a very important aspect of the project. It is a very, very participatory, involving aspect of data collection, and it is, it's exciting. Now, mapping is a very broad category of data collection, right? And specifically for that project, we focus a lot on the environment and the sort of natural resources that exist in the communities. So we're gonna ask questions about the landscape, the seascape, the mountain, the forest, the trees, the plots, the grassland, the waterways, and having community members identify where they are, plotting where they are. So it's a collection of all of these resources that we would have available. So it's like a one-stop shop for information about the community.
Well, Grenada is a small island developing state, and we are very vulnerable to the impacts of climate change. And agriculture is one of our sectors, one of our most important sectors, and that sector has been identified as very vulnerable to climate change. So in the Integrated Climate Change Adaptation Strategies Program, for short is ICAS, we have identified the sector as one of the sectors we want to work with in terms of building its resilience to climate change through adaptation strategies. So we are working in the sector and looking at its water use, because the water sector is also a sector that has been identified as very vulnerable. So we're looking at how it is that the agricultural sector could increase its resilience to climate change through its water use. And the Mount Morris area falls within a watershed, and it also leads to the Molineux-Bouchejou Marine Protected Area. So we are looking at how it is that that community could use the resources within the watershed more efficiently, and using agriculture as the medium for this.
Well, things have changed. A lot of the older people who was really involved in farming have died out, and not much young people is picking up on it. We still have a number of people who do the farming now. One of the main challenges we have now is less rainfall. As you would observe, I depend solely on Mother Nature, and over the last 10, 15 years, there have been less and less rainfall.
As a ministry, we are building 3 intersectoral linkages. So I would like to say that to put our discussion in context. The first one is what most people would be aware of, is the linkage between agriculture and health. Remember, Eat Local, Buy Local, Zero Hunger. These are the programs at the forefront of that thinking. The second linkage is between climate change and agriculture, or you could say agriculture and environment, because climate change is just one aspect. And in light of the link between agriculture and environment, we have the Green Adapts program, where we call on everybody to adapt to climate change. So we have projects under the GIZ and projects under the UNDP. They are the implementing partners of the ICAS project. The third linkage we would like to establish is between agriculture and tourism, but that is in its, say, genesis stages. It's not launched yet.
Well, the projects haven't really started as yet, but I think there's a number of farmers that is behind the project. We in Mount Morris welcome the project because we see it as a good for the community. And so we've been working along with Ms. Denise, trying to get things in place. She has been assisting us in some training and so on. For example, I've been to a permaculture design course. I have my certificate. So as from, it was earlier this year, so as from this planting season, we will try to put into practice, what I have learned, and try to assist other farmers in implementing that type of farming, climate-friendly farming.
Out of the training of permaculture, 6 examples were made. These 6 examples, or demo sites that were developed, are in addition to the model farm. And these came about quite naturally. There was quite a demand for the permaculture training, where we were able to entertain about 36 persons for the training itself. From that training and those 6 examples, we had the prison, Her Majesty's Prison in Richmond Hill, who are now have now designed their farms and are interested in making a sustainable prison. We are now teaching permaculture inside of the prison as well. We have 3 persons in the prison who are trained in permaculture. We also have the Moringa Farms of Pride of the Meadow in Conference, St. Andrews, where a family is doing a 2-acre farm. They've taken the whole design very seriously, and without funding and without any further help, but a lot of conversation, they have gone so far as building their own ponds and check dams. They've done their swales already, so they're actually practicing a lot their principles, both them and the prison.
Actually, from the trainings, other persons have been interested and have started using the permacultural practices on their farms, which is very good. It's been replicated already, which is success for us and for PIA. So by the next year is when the project would end from GIZ's perspective, but from PIA and the overall project, it's a lifelong learning institute, so this project would go on for a lifetime.
The new coronavirus, too small to see, spread quickly from person to person, town to town, and country to country, to all corners of the world. Any one of us can catch it, spread it, and get sick. When a person infected with coronavirus breathes, talks, coughs or sneezes, tiny droplets with millions of harmful viruses spread into the air and land on everything nearby. Without realizing, the viruses enter our body. We breathe them in. They land in our mouth, nose, and eyes. And we pick them up on our hands, then touch our eyes, nose, or mouth. In these ways, the viruses enter our body and infect us. Most people don't get very sick with coronavirus. We can have this virus and not know it, and easily pass it to others, who pass it to more people. In a few weeks, a whole neighborhood can get infected. Most people who get sick get better on their own, but some, especially the elderly, and people who already have illnesses, can get very sick and even die. Coronavirus spreads when people are close together. To protect ourselves and each other, we need to stay away from crowded and enclosed places and keep our distance. Wear a mask to protect others and ourselves. Keep our hands away from our face. Cover our cough or sneeze using our bent elbow. Wash our hands often and well with soap and water. And clean surfaces that are touched often with disinfectant to make them safe. All these actions can help stop the spread of coronavirus and keep ourselves, our family, and our communities safe. You can follow these actions and stay safe too.
During this time of the novel coronavirus, COVID-19, literally every face-to-face meeting, conference, and class has been cancelled in favor of going online. However, we must remember to cater as best as possible to the deaf and hard of hearing. We implore members of the private sector and users of social media to use the services of a sign language interpreter where and when possible. For further information on how to assist the deaf and hard of hearing, contact the Jamaica Council for Persons with Disabilities at 876-926-9376 or 876-618-1133. We ask all our stakeholders to play their part in catering for persons with disabilities. Take care of our persons with disabilities, not only today, but every single day. A message from the Ministry of Labour and Social Security.
Public sector transformation is a comprehensive program that looks at the reform of the public sector in Jamaica. It was one of the programs that came out of the IMF latest program with Jamaica, and the IDB and the World Bank and others committed to funding programs that would help the country meet those targets and commitments that they made under the IMF program. Specifically under the public sector transformation, we're looking to modernize the way that the government handles human resources, centralize certain specific services, and also digitize and modernize certain type of public services. A big push for digitization has come from the COVID-19 crisis. We estimated that in the Latin American and Caribbean region, only about 20% of government processes used to be online before COVID. Today we're up to 41, which is an improvement that happened just in a couple of years, something that in normal times would have taken maybe a decade, and now it has taken only about a year or so. It's a highly strategic program that goes right to the core of modernizing the country. You know, if you look, for example, at the administrative processes that we're digitizing, the human resources. This is about eliminating hundreds of thousands of pieces of papers, making people's lives easier, and meeting the government's commitment to make Jamaica the country of choice to live, do business, and raise your children.
The Inter-American Development Bank has been a consistent development partner of the government of Jamaica. They have funded several projects over the years geared towards building a better public service. For the Transformation Implementation Unit, the IDB has provided us with a loan of $50 million spread across 5 project pillars that we have developed here at the TIU in collaboration with public sector employees, heads of departments, permanent secretaries. Some of the projects we've been working on here at the TIU have been the development and implementation of shared corporate services, the rollout of GovNet, the establishment of a new compensation structure for the public service and the transformation of our human resource management. Some of the successes we've had so far include the establishment of two very important pilots for shared corporate services. That is the provision of HR services, administrative services, along with internal audit services. Now, these two pilots are important because these are the two pilots that will prove the business case that shared corporate services does provide the route to the delivery of efficient and effective services. And these are services that are internal to the public service. We have also undertaken the rollout of My HR Plus. My HR Plus is an integrated human resource and payroll management system. This provides the public service with information on its employees and also provides employees with the opportunity to manage some of their HR needs seamlessly online. My HR Plus has been rolled out to 40 public sector entities, and we currently have 67,000 public sector employees on My HR Plus. One of the critical projects that we have undertaken here is the rollout of GovNet, and to be specific, the rollout of GovNet Core. And what do I mean by the rollout of GovNet Core? GovNet Core is the establishment of the government's secure private network to enable online communication, secure online communication, data sharing in a secure environment. It also enables the government to host its own cloud services to store its own data. Now, this is critical because as we move towards digitization, not just of our public services, but to allow for accessibility across the country, it is important that the public service has its own platform so that it is able to provide services in a seamless manner to citizens, customers, and businesses. The future for the public sector being enabled through what we call these foundation projects funded by the IDB for us is digital. We are looking at the ability for the public service to pull on its own data that it generates in a manner that is efficient, that allows for more policies that are information driven. We are looking at data analytics, providing answers to policy issues and policy research at a level never before encountered in the public service. We are looking at using the technology to provide services exactly where citizens are, whether they are here in the center, Kingston and the corporate area, or if we are outside of Kingston and the corporate area in our other parishes. We are meeting our customers where they are. We are building a modern public sector, providing high quality services for everybody.
Coming in April. The point of wearing a mask is to prevent the spread of air droplets from persons who may or may not be infected. When wearing a mask, please ensure that the mask goes above the nose and below the chin. This might be a bit uncomfortable, but it's for your own safety. The position of the mask is very important. It should not be worn on your forehead, under your chin, or on your neck. Please do not remove the mask when speaking. This actually causes more droplets to be released into the atmosphere. Trust me, if you have on a mask, we will still hear you. When you're removing a mask, try not to touch the front of the mask. If you do, remember to wash your hands or use hand sanitizer. Please throw away the mask appropriately. Remember, partial protection is better than no protection.
Hello, boys and girls. My name is Anne Harvey, and I'll be your guide once more throughout this wonderful journey called learning. Today, we're going to begin with a challenge called What Would You Do? Challenge number 1. To get as many fruits as you can with $200. Now, in this scenario, there hasn't been a lot of rainfall for the last 3 months. The farmers have not been able to grow many fruits, and so fruits are scarce. Now, when fruits are scarce, the prices go up. Tony only has $200, which he plans to spend buying fruits in the market. He likes bananas and apples and oranges. He goes over to Mrs. Jones, and she has bananas for $450 per dozen, right? Apples for $400 per dozen, and oranges for $500 per dozen. Now, what would you do? Would you leave it or would you buy it? And you know what? Guess what? You don't have to leave empty-handed. $200 can actually get you a banana and get you an apple or an orange. You will have to use what we call mathematics to solve that problem. Let me know how you dealt with that challenge. Every day, boys and girls, we are faced with problems. Some big, some small, but we can use our mathematical skills to solve these problems. And guess what? And to make good decisions. In today's lesson, we'll be looking at our mathematical skills to solve real-world problems and make decisions. For this lesson, you'll need your pen and your notebook, and I'll give you a couple of seconds to run and get them. 5, 4, 3, 2, 1. You ready? All right. So you're almost ready now for class. So what we're going to do now, we're going to warm up that math part of the brain. And let's go. Now, remember, you must make your notes as we go along. Children, I want you to listen very keenly. And your parents out there, I want to ensure that these children have a quiet place to sit, listen, and learn. Parents, you also can take on the challenge as well, and see how well you and your child can work together to solve problems. For today's lesson, we'll be focusing on problem solving and decision makings. We'll be using the topic weather and climate to develop these skills. At the end of this lesson today, you will be able to use mathematical skills to solve problems. And of course, use mathematical skills to make good decisions. All right, what I want you to do right now, I want you to listen to this news report. And as you watch and you listen, try to identify the problem that is reported.
Sections of the corporate area were again flooded after heavy rains associated with an area of unstable weather linked to Hurricane Delta. Poor drainage is being blamed for the flooding being experienced on Marcus Garvey Drive. Videos received by our news team showed persons pushing their vehicles in almost waist-high water along the 6-lane road. That issue has been a long-standing one.
Thank you, Vashon Brown. I'll take it from here. So, boys and girls, what problem have you identified in this news clipping? The main problem was the flooding of Marcus Garvey Drive in Kingston. All right. Now, we need to solve the problem. So to solve the problem, we need to find the cause of the problem. So what is causing the flooding across Marcus Garvey Drive? I hear Anna from St. Mary saying it's the heavy rain. And Neil from St. Anne is saying the blocked drains. Who is correct? All right, let's reason this out. What is the real cause of flooding? Well, the roads can be flooded if rains fall heavily. Yes? So heavy rainfall can cause flooding. But if the drains are large enough and are clean, chances are there will be no flooding. All right, let's look at another cause. Let's think. Blocked drains. Will there be flooding if we have large drains that are blocked by garbage? There definitely will be flooding if the drains are blocked. And we, of course, cannot control the amount of rainfall, but we can clean the drains, right? So, can mathematics help us to clean the drains? But it sure can tell us the best time to clean the drains. So we're looking at time now. All right. Let's look at this chart. We're going to look at the average rainfall data from the Met Office. Now remember that the Met Office is the agency that provides us with all things about the weather. So in this data, it shows the average per month for the last 30 years, that is from 1971 to 2000 for Kingston and St. Andrew. Now, we want to look at this data very keenly. All right. Here we have January, and in it we have 70 millimeters of rainfall. February follows with 72, March 67, April 93, May 152 millimeters, June 98, July 65, August 147, September with 206, October 241, November 160, and we round off with December with 79 millimeters of rain. All right. Now that we have all the data, let us use it to help solve the problem. So to solve the problem of flooding, we definitely need to clean the drains. All right? But what we need to decide is, when is the best time to clean the drains? So we will use this data to help us decide. You can't clean the drains when there is a lot of rainfall, right? All right, we agree on that. So we have to now look for the months when there is less rainfall. Ready? Let's look. Which month received the least rainfall? All right. July received the least rainfall of 65 millimeters, followed by March, which received 67 millimeters. All right. We also have to identify the months with the most rainfall so that the drains are clean before the heavy rainfalls. You see, you're working with me here now. All right, let's look. October received 241 millimeters of rain. That's the most. September received 241 millimeters, and November received 166 millimeters. This is clearly a rainy season, right? Yes. and may also receive good amount of rainfall too, and this stands at 152 millimeters. So there are 2 rainy periods. Therefore, drains should be cleaned at least twice per year. I see that you're working very good. Now, question now, which months would be best for cleaning the drains? Remember now, we need to choose 2 months, one before the beginning of each rainy season. Which months would you choose? All right, I'm hearing it. March and July. Yes, great boys and girls. These are good choices because there is less rain. It is much easier, don't you think, to clean the drains during the dry weather. Also, you do not want to clean the drains too early, lest what? They become filled with garbage and other debris before the rains begin. Okay, students. So we have used our mathematical skills to help us to solve a problem and make a decision. We used the average rainfall and we compared quantities. Good job. All right, let's solve another problem using our mathematical skills because we are getting so, advanced and professional now. Come on. This time, the problem is to decide where to set up a rainfall harvesting system for farmers. Now, a rainfall harvesting system usually includes a tank which stores water for use during periods of no or low rainfall. All right? So that's the situation here. We will now use the average rainfall data collected over 30 years. So let's take a look. The areas to choose from are, we have Millbank, which received 420 millimeters of rainfall in May. We have Langley, which received 259 millimeters of rainfall in May. And the third one is Bernard Lodge, which received 85 milliliters of rainfall in May. All right, now let's go. Where would you set up your water harvesting system? Let's look at each place again. In the month of May now, Millbank receives 420 millimeters of rainfall in 1 month. Would the farmers in that area need water harvesting system? Maybe. All right, let's look again. Is there another place that would need it more? Let's look at Bernard Lodge. It received 85 milliliters in the same month. Would they need it more? All right, most definitely. They do not get as much what? Rainfall as Millbank and Langley. Because Langley received 255 milliliters of rainfall. Now, since Bernard Lodge receives the least rainfall of the 3 places, then it would be best to set up the rainwater harvesting system there. Where we're helping out the farmers now, where the farmers will be able to use the water from the tanks when there is no rainfall. Come on, with all these ideas, let the government employ us now. We have done it again. We have used our mathematical skills to solve a problem and to make such a great decision, eh? Come on, give yourself a round of applause. All right. We need to use the average rainfall received over a 30-year period to decide where to set up a rain harvesting system. We have done such a great job. I don't know about you. I feel really good about this. All right? Okay, boys and girls. Let's revise what we have learned today. We have learned how to use mathematical skill to solve problems. And we have solved problems and we have made good decisions by looking at the averages and we have compared these quantities. Now listen, here's an activity for you to do before the next class. Identify a problem within your home, school, or community which can be solved using mathematics. Now, remember, explain the problem and then describe how you will use mathematics to solve the problem and make a decision. All right, boys and girls, that's all for today. I thank you so much for participating in this lesson. We hope you have learned something new or you were able to revise what your teacher has already done with you. Now, remember, please stay safe. Remember to wear your mask, wash your hands. Walk good now. Until next time.
Jamaica is a beautiful place. Our people have a beautiful spirit, but we are too aggressive, and the way we interact with our friends and neighbors, I genuinely believe that we have the capacity to deal with this problem of violence. But it's going to take all of us. It's going to take every organized group of Jamaicans that we fundamentally reject violence. Violence has no place in a modern society.
She's got heart, she's got style, and she'll make it worth your while. She's got good news to help you. Get rid of the stress, just relax and be blessed. Listen, watch and grow with the Nadine Show. Won't you come on in and be blessed? That's what you get when you're on the Nadine Show. You'll be pointed to the Most High. Oh yeah, that's what you get when you're on the Nadine Show. Won't you come on in and be blessed? That's what you get when you're on the Nadine Show. You'll be pointed to the Most High. Oh yeah, that's what you get when you're on the Nadine Show. You will be lifted and blessed by the Lord Most High when you're with the Nadine Show.
Hello, boys and girls, and welcome to our Social Studies lesson series. This is Term 1, Unit 1, and our theme is Our Common Heritage. My name is Anne Harvey, and I'll be your guide throughout this wonderful journey called to learning. During this unit, we're looking at the people who came after emancipation. That's right, we're looking at the East Indians and the Chinese. Well, in today's lesson, we are happy to give you the assistance to guide and support your preparation for your examination. Our study focus will be on the East Indians and the Chinese. So, to get ready for today's class, you will need your pen and your paper, your social studies resource book, and of course, your undivided attention. You must remember, too, to take your notes as we go along. So, let's begin. So, we should be familiar with the map of the world. And of course, you know the parts of the map, their purpose, and function. Of course, you were once asked by the teacher to create your own thematic map, showing the place of origin of the ethnic groups that came to the Caribbean. Now, you'll be asked to locate the areas on the map of a particular group of people from the continent of Asia. Let's now examine the map of the world. This map shown on your screen is color-coded for your benefit, so that we can quickly recall the different areas of the world. We must remember too the size of the landmass of the continent. As you can see, the landmass of Asia is what? Much larger than the others. That can be a clue to help you to remember to locate the two groups from Asia. Let's now look at our question. Which groups originated from the areas labeled X and Y above? We have recalled the location of the places of origin by using the color-coded strategy and establishing which is the largest landmass among the continents. Let's look at our options. Option A says Africans and Chinese. But we know those two groups never originated from the same continent, nor came to the region at the same time. Option B says the British and African. Yes, we know that the British came from Europe and were the colonizer, and the Africans, yes, the enslaved people. And surely they were not a part of the same continent. Let's take a look at option C, East Indians and British. As far as we know and can recall, the location of the British were, as discussed, and identified that they were located above the continent of Africa. So, that's not the answer, is it? No? All right, let's look at option D, the East Indians and Chinese. We have heard that both of these ethnic groups originated from the same continent. So, our answer is option D. The East Indians came from India and the Chinese from China. Very good, boys and girls. Our next question, we will look at the push and pull factors that led to the migration of the East Indians and Chinese to the Caribbean. Let's recall what are pull and push factors. Pull factors are the things that seem better on the other side of the grassing, that cause someone to be attracted to a place. Pull factors are the generous benefit found on the other side, like health benefit, wealth, rights, freedom, better wages. While push factors are the things in your immediate situation that causes you to leave a place. In the person's immediate situation, it could be unhappiness and sorrow because of lack of job opportunities, overpopulation, poor health care, low wages, crime, violence, even natural disasters. So push factors are the things that can cause one to leave their country or community because of lack of opportunities. And pull factors are the things that attract someone to a place, things that will make their life even better. Now that we have distinguished between the pull and push factors that led to the migration of the East Indians and the Chinese, let's answer the following question. Mr. Ramsack left India in the late 1800s and migrated to Jamaica. Which was a push factor for him? Let's look at our options. A, poverty. B, job opportunities. C, hope for a better life. And D, good weather conditions. Remember now that push factors are the conditions or situation that causes someone to leave. And your answer is A. That's right, poverty. Poverty is one of the many things that could cause a push so that the person would leave his or her country or community. As you know, the East Indians and Chinese came to the Caribbean during the 1800s to work on the plantation. As you already know, that they came to replace the enslaved Africans who were given their freedom and many had left the plantations. We will now take a look at the goods and services offered to consumers, and then we will examine the contribution of the East Indians and Chinese to the Jamaican economy. Of course, when we use the term economy, we know that we are talking about the production and consumption of goods and services, and of course, the supply of money. We can recall from our lessons that The goods are the items that are made to be sold, which satisfy human needs and wants for such things as furniture, clothing, and food, while services are the activities provided by other people for which the consumer is willing to pay. These services include barbering, medicine, repairing cars, selling insurance, and hairdressing. These are the services for which you will pay. So now let's take a look at our cultural contribution of both the Chinese and the East Indian. There are clearly links between goods and services that they provide. In this question, we will read the sources, and source 1 reads, East Indian cultural contribution. Delightful dishes, curry and roti, religious festival, Diwali, and owners of jewelry store. In source 2, we have the Chinese cultural contribution, the tasty dishes of sweet and sour meats, Chinese New Year, and owners of grocery stores. The question asks, for each statement, indicate whether the information can be found in source 1, source 2, or both sources. Here are the statements. Some ethnic groups have made significant contribution to the Jamaican economy. Would it be source 1, source 2, or both sources? Your answer is C. If your answer is C, congratulations, you are indeed correct. They both made significant contribution to our Jamaican economy in the form of goods and services. The next statement reads, some ethnic groups celebrate secular festivals. So we must remember from our previous lessons that there were two major types of festivals. One is secular and the other religious. Secular means non-religious. These festivals are not concerned with worship, while in contrast, religious festivals have to do with, yes, worshiping and the adoration of something or someone or a divine or spiritual being. Let's take another look at the two sources and then attempt to answer the question. Some ethnic groups celebrate secular festivals. Your answer? Yes, indeed, source 2, which is option B. Chinese New Year is a secular event. That's great thinking, boys and girls. Okay, boys and girls, you have certainly done a great job with these questions. You have recalled all that your teacher has taught you, and so that is very, very good. We encourage you to continue to pay attention in class, study hard, get enough sleep, create a study group with your friends, and please, 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 do so by asking your parents' permission. And I know it will be all good for you on your exams. Well, that's all for now, boys and girls. And as usual, remember to wash your hands, wear your masks, maintain your physical distance, be safe, walk good now. Until next time.
The National Family Planning Board now presents a parenting tip from Andy Swithson. The sign of great parenting is not the child's behavior. The sign of truly great parenting is the parent's behavior.
A major area in high school for me was IT and EDPM. I did that for 2 years, and from then I realized that there was a drive for more of technology. So I decided to take this step.
Hello, boys and girls, and welcome to our Social Studies lesson series. My name is Ann Harvey, and I will be your guide once more throughout this wonderful journey called learning. In today's lesson, we'll be looking at performance tasks exercises. As you may know, performance task is a learning activity designed to help you, the students, to demonstrate your knowledge, your understanding, and proficiency through a variety of methods that serves as evidence of learning. There are, of course, a number of skills to help you in mastering the performance task given. Such skills are telling the differences between fact and opinions, using context clues, understanding charts and graphs, finding evidence to support statements, identifying main ideas and supporting details, writing letters, writing reports, and paragraphs. In today's performance task activity, we will look at the topic Caribbean culture and utilize the skill finding evidence to support statements. Let's begin. In our learning outcome, we will read 3 sources, write important points from each of the sources, then answer questions to state whether the information is supported or not. In this task, we will begin by reading 3 sources on Caribbean culture. Source 1 is an article about music and dance. The other article is on language, and the third is a table showing various religious groups in the Caribbean. Now, let's take a look at these sources. In source 1, we will read, sometimes you want to get up and dance. Music compels your body to move. Think of salsa, mambo, reggae, and calypso. They're all a part of Caribbean dance, which involves vibrant music and moves. Have you heard music from places like Cuba, Trinidad, Jamaica, or the Dominican Republic? These Caribbean islands have strong cultures of music and dance. Caribbean dance evolved from complex influences, including slavery and colonization. Enslaved Africans brought to the islands to work on vast plantations carried their customs and drumming traditions with them. Using available materials, they crafted instruments and kept elements of their cultures alive, while the English, French, and Spanish colonists came with their music and dance customs. Over time, customs blended and became new music and dance. Regardless of the style, there's a particular pattern in historical development. Afro-Caribbean people maintain and build on dance custom throughout time. Although initially looked down by those in the upper class, who regarded these expressiveness and body moves as salacious and vulgar, the styles persisted and they evolved. They grew in popularity, first in the local neighborhood, and then found their ways to broader appeal. All right, that was source 1. Source 2, we will look at languages of the Caribbean. The languages of the Caribbean reflect the region's diverse history and culture. There are 6 official languages spoken in the Caribbean. The 6 languages are Spanish, which is the official language of Cuba and Dominican Republic, French, which is the official language of Guadeloupe, Haiti, and Martinique, English, Dutch, and Haitian, and Papiamento are Portuguese and Spanish-based Creole. Source 3 will look at religions practiced in the Caribbean. Now, this is a table showing the various religions, their total number, and their percentage. We have Judaism, Islam, Hinduism, Christianity, and of course others. Now that we have read all three sources, it is now time to write the important points from the sources. Now, from source 1, what was the main or important point for you? You could write, a mixture of culture brought a mixture of music and dance, like salsa, calypso, and reggae. And from source 2, what could you write? Each colonial country brought their own official language, and so over the time, each country that was colonized had the language of their colonial rulers as the official language. And from source 3, what would be the main point for you? You could write that Christianity ranks the highest among the other religions in the Caribbean. Okay, boys and girls, now that we have written our main points, we will now move to the next section of the performance task, where we will answer some questions. Now, these will be a set of 3 statements. After reading each statement carefully, we will be asked to indicate with a check or a tick whether the statement has supported the sources we have just read or it doesn't support the source at all. And we can always skim and scan to ensure it is so. So let's take a look at the following statements. Statement number 1 says, English and Spanish are the only languages spoken in the Caribbean. Do we recall reading that? So we need to look at our options here. Does source 1 support this statement? Is it source 2? Or is it both? Sources 1 and sources 2 support this? Or neither source 1 nor source 2 support this? So we have to think about this, boys and girls. Your answer? That's right. Neither source support this statement, because we have read that though there are other languages that are spoken other than the English and the Spanish. And it had been mentioned that there are languages such as French and Dutch. So of course what we're going to do, we will indicate our answer with a tick. All right, now, it seems as if we're doing great so far. So let's move on now to the next statement. It says, the names of music and dance varies in the Caribbean. Does source 1 support this statement? Is it source 2? Or both 1 and 2 support this? Or neither source 1 nor 2 supports this? Let's think. Your answer? That is right. Source 2 doesn't support this statement. We indicate the answer by drawing a tick in the box. And the last statement we will look at, that reads, various ethnic groups influenced the Caribbean's dance, music, and language. Does source 1 support this? Is it source 2? Do both source 1 and 2 support this? Or is it neither source 1 nor 2 supports this? Your answer? That's right. Sources 1 and 2 do support this statement. And of course, we will indicate our answer with ticks inside the box. And now, the last question we have is this. Using the details from the source 3, identify the top 3 religions in the Caribbean. And so as we look through the table, it will give us the information. It is Christianity, other, that's not mentioned, and Hinduism makes up the top 3 religious groups in the Caribbean. All right, great job now, boys and girls. We are doing great so far, and I know that you guys are sure winners. Now, to round it all off, we come to this section where we are now ready to write a report on Caribbean culture. We have sharpened our skills based on the information gathered. From the sources, we have written the important points. We have also indicated whether the statements that were given were supported or not. Plus, what your teacher has already taught you on the subject. And so we will put all these things together and we will write a report. And our report will be looking at aspects of Caribbean culture. That is, the dance, music, and language. Now, it is time for you to write your report. Remember now, when writing any report, remember the writing process of plan, draft, edit, and write. And of course, if you remember to follow the rules of capital usage, punctuations, and spelling, I think you'll do great. Now, best of luck on completing this task, and we will be so excited to hear your report in the next lesson, because I know it's going to be great. So, let's review what we have learned. We do realize that the performance task can be fun and it can be exciting. You, using your knowledge, your critical thinking skills to complete given task is nothing at all to worry about. You would have read at least 3 sources and then write the main points from each source just to keep that information fresh in your mind. Then, of course, you answered questions to say whether or not the statement match what you have read. Then now, reviewing your important points and the sources, you then plan, you draft, you edit, and you write your report. And then, voila, you would have written the most beautiful report ever and received good marks. Yes, boys and girls, I believe in you. So, start practicing, boys and girls. Get your friends on Zoom, but of course, ask your parents for permission. And start your performance task practicing, call it 101 sessions, and you will be happy you did. Okay, boys and girls, so we have come to the end of another exciting lesson in our series. I thank you so much for your participation, and we do hope that you have learned something or you were able to revise what your teacher has already taught you. Alrighty then, until next time we see each other, please do remember to be safe. Wear your masks, wash your hands, walk the good now. Until next time.
You know, plan to support the ref for them up, improve the ball field. Where we are going? After somebody don't know the prize. Youth, worry yourself. For once it's a good cause, nothing wrong. Nothing wrong. It have to be approved by the Betting, Gaming and Lotteries Commission before anybody get my hard-earned money for any raffle, no matter what.
Promoting any unauthorized gambling activity is a criminal offense. Bingos, raffles, gaming machines, poker boxes, sweepstakes, betting, and any activity where payment is accepted in cash or kind in exchange for a chance to win prizes are gambling and will be illegal unless approved by the Betting, Gaming, and Lotteries Commission. Persons who intend to promote any kind of gambling activity must apply to the BGLC for approval. For more information, call 876-630-1353 or visit bglc.gov.jn.
Twists, turns, ins and outs. From the four corners of the earth, PBCJ presents Globe-Trotting Yardie with Carol Francis.
There are numerous ways of traveling across the city of Delhi.
Tantalizing, breathtaking, and revealing, bringing you the wonders of travel from across the world. That's Globe-Trotting Yardie, right here on PBCJ, the People's Station.
Small businesses like mine continue to serve the needs of people.
We all play a part in keeping the wheels of our economy turning, and we do so responsibly.
We are building forward
together.
You remember the water bill what me tell about the other day?
There are always some questions or concerns about our utilities and our rights as customers. The OUR answers those questions in Utility Matters. Join Cashco and Patrick.
Switch your phone provider.
And Cordell and Trixie.
The OUR is here to work for all of we. Them, you, and me.
As they share their stories and solutions on Utility Matters. Utility Matters is brought to you by the Office of Utilities Regulation, regulating utilities for the benefit of all.
Catastrophe. A guest! Where?
Hello? Hello? I'm here.
Oh, there, Mum! Oh, Mr. Squigglebottom! We've been expecting you. We welcome you with fairy arms!
Be careful, Mum. He's small.
Oh, yes. You are rather on the small side, Mr. Squigglebottom. I better welcome you with furry fingers. There you go.
Thank you. Is my room ready?
Oh, yes, Mr. Squigglebottom. We're giving you the best bed in the hotel.
Oh, I don't need a bed. I'm a caterpillar. I only need a twig.
Then you'll love our twig room.
Can Elmo show Mr. Squigglebottom to his room?
That would be a big help, Elmo. Just be careful he doesn't get squished.
Okay. Come on, Mr. Squigglebottom.
Watch out, Elmo!
Watch out, Elmo!
Are you okay?
Yes, I think so.
Oh, nice footwork.
Oh, well done, Elmo.
Okay, Mr. Squigglebottom. There you go. Welcome to the twig room. Ta-da! Oh, but where will Mr. Squigglebottom sleep?
On the twig. But first, I'm going to make a chrysalis.
A what now?
A chrysalis. It's like my very own sleeping bag.
Oh, cool. That sounds cozy. Oh, wait, Mr. Squigglebottom, like anything else?
Well, yes, I am rather hungry, Elmo. Could you please get me a tasty leaf for my supper?
Okay, right away. Okay, Mr. Squigglebottom, here you go. 1 leaf.
Oh, thank you, Elmo. Just pop it down there.
Okay, here you go. Bon appetit.
Thank you. I'm still hungry. Another leaf, please.
Okay, right away. Another leaf, please. Another leaf.
More leaves coming right up.
Another leaf, please. More leaves, please.
More leaves? Me on it.
Oh. Where are the leaves, Cookie?
Oh, thing is, Mr. Squigglebottom, me thought you'd like a change from leaves. So, me have something even better. Cookie!
Thank you, but I'm all full.
Well, that relief. Seems shame to waste, huh? Cookie!
Bye-bye, Mr. Squigglebottom.
Bye-bye. Time to make my chrysalis. Wow, that was some night. I feel transformed. What a big change. Squigglebottom, you are one magnificent butterfly. Now let's try out these wings. How lovely to be outside in the sun.
Good morning. My name's Miss Scuttles. I'm meeting my friend, Mr. Squigglebottom. Is he here?
Ah, yes, Miss Scuttles. He's in the twig room. I'll phone him. Oh, that's odd. There's no answer.
I hope he's all right. I mean, I'm sure he's all right. There's no need to panic. Fergus, we have a problem. Oh!
Someone knows where to look.
We'll find him for you, Miss Scuttles. We Furchesters are great at solving problems. Would you like to wait in the bowling alley?
Oh, that sounds lovely.
Mr. Squigglebottom?
Mr. Squigglebottom!
Oh, he was here yesterday. Oh, maybe Mr. Squigglebottom is in Mr. Squigglebottom's sleeping bag. No, Mr. Squigglebottom's sleeping bag's empty.
Then where is he? I mean, he can't have fallen out of the window.
We've lost a guest!
Oh, this is a huge problem. It's a catastrophe!
It's more than just a slip-up or a mess-up or a mishap. It's just a catastrophe. We need to fix it fastrophe. Put it in the apostrophe. Let's ding the bell for blastrophe. Catastrophe, catastrophe. Catastrophe, catastrophe. It's a catastrophe, catastrophe, catastrophe. What's an apostrophe? It's a catastrophe. What a disaster. It's a catastrophe.
I'm right here. We've never lost a guest before. Well, not since the last time.
What do we do?
We need to think like a caterpillar.
Yes! If you were a caterpillar, where would you go?
Well, caterpillars are small. And Mama thinks if he was a caterpillar, he'd hide. No.
Excuse me, can I have some towels for my room?
In a moment, sir. We've lost a guest.
Typical.
Not under the sofa.
He was very hungry. Maybe he wanted more to eat. Now, if I were a hungry caterpillar, Where would I go to get leaves?
The garden! Come on, everybody!
Oh, any sign of Mr. Squigglebottom in the garden?
Oh, we'll keep looking, everyone.
Oh, oh, we've got to find him.
Oh, now, wait. We've got to put our furry heads together and think.
Okay.
What do we know so far?
Mr. Squigglebottom wanted a room with a twig.
Right, then Mr. Squigglebottom ate a lot of leaves.
And then Mr. Squigglebottom went to a sleeping bag.
Sleeping bag?
Yeah, he called it something like a chrysalis.
Oh, Elmo, that's it. When a caterpillar has made a chrysalis, he changes into a butterfly. Fuzzer wubber. Well, that gives me a monster idea. We should be looking for a butterfly.
Like that one?
That hat looks just like Mr. Squigglebottom's hat. That butterfly must be Mr. Squigglebottom.
That's right. Yes, it's me.
Mr. Squigglebottom, you've changed. You're not a caterpillar anymore.
It's no wonder we didn't recognize you.
Well, Furchesters, we've solved the problem. We found Mr. Squigglebottom.
There you are, my friend. Oh, what wonderful wings. I'd love a pair myself.
You should stay in the twig room. It will change your life.
A great idea. Check me in. Say, I'm feeling really hungry. Could you send me up some leaves?
Cookie Monster?
Yeah.
More leaves, please.
Right. More leaves? Oh.
You really can't be going. They say it isn't true.
The Furchester will never be as furry without you. So don't check out.
Don't check out.
Please, 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 please don't go.
Don't check out.
Don't check out.
No, 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 no. Please, please don't check out. She's got heart, she's got style, and she'll make it worth your while. She's got good news to help you. Get rid of the stress, just relax and be blessed. Listen, watch and grow. With the new English show, won't you come on in and be there? That's what you get when you're on the new English show. You'll be pointed to the most high. Oh yeah, that's what you get when you're on the new English show. Won't you come on in and be there? That's what you get when you're on the new English show. You'll be pointed to the most high. Oh yeah, that's what you get when you're on the new English show. You will be lifted and blessed by the Lord most high when you're with the new English show.
What if they knew that you abused her? Her family?
Mr. Jones.
And your colleagues, how will they look at an abuser? When the law comes knocking, you'll have nowhere to run.
Mr. Brown, you're under arrest. Please get up, hands behind your head and interlock your fingers.
Turn your back on abusers report gender-based violence to the police. There's no excuse for abuse. Call the Bureau of Gender Affairs at 876-754-8577.
Jamaica Eye is part of an island-wide network of camera surveillance systems designed to increase the safety of you, our citizens. If you have a camera system outside your home or office facing a public space, join us in helping to make Jamaica a safer place for all. Log on to jamaicai.gov.jm today. Jamaica Eye, we're all connected. The Ministry of National Security, creating a safer and prosperous Jamaica.
The National Census is an opportunity to help develop your community and create a brighter future for your family. The information gathered from the census is used to make important decisions about where to put facilities like clinics, stores, and new roads. So be seen and be counted for your family's future. Census Day is September 12th. Look out for the National Census takers in your community and let them know you count.
She's got heart, she's got style, and she'll make it worth your while. She's got good news to help you. Get rid of the stress, just relax and be blessed. Listen, watch and grow with the Nikita Show. Won't you come on in and be blessed? That's what you get when you're on the Nikita Show. You'll be pointed to the Most High. Oh yeah, that's what you get. When you're on the Nikita Show, won't you come on in and be blessed? That's what you get when you're on the Nikita Show. You'll be pointed to the Most High. Oh yeah, that's what you get when you're on the Nikita Show. You will be lifted and blessed by the Lord Most High when you're with the Nikita Show.
It's Wednesday, April 12. In the headlines, Jamaicans are being urged to follow immigration laws of the countries they visit. In business news, MasterCard to deliver eco-certified cards by 2028. In regional news, no strict measures on Jamaicans going to Belize just yet. Internationally, leaked Pentagon documents under investigation. And in sports, Cricket West Indies names squad for Headley Week's Tri-Series. This is the news on PBC Jamaica. I'm Simone Absalom Gale. Jamaicans are being urged to abide by the immigration laws governing the countries they visit. The advice comes from Minister of Foreign Affairs and Foreign Trade, Senator Kamina Johnson-Smith. There have been reports of irregular migration of Jamaicans recently in Belize, Mexico, and Panama.
The government of Jamaica, however, does continue to consult at varying different levels with our partners in Belize, Mexico, and Panama. We are very concerned that Jamaicans are taking decisions to travel in circumstances that are extremely risky, and in some cases taking children with them, exposing them to dangerous situations including kidnapping, trafficking, and even death.
Minister Johnson-Smith said most Jamaican travelers to Belize, Mexico, and Panama travel for legitimate reasons.
We want to really ask Jamaicans to think, while this matter is at this, I would say, comparatively small numbers, when we look at some of the other persons within the region that are using Central American routes to try to transit elsewhere. While our numbers are relatively small, we do not want the immigration experience of our lawful travelers to get worse.
News came last week that Jamaicans will be required to show proof of hotel reservations when they travel to Belize. Reports are that Belize's government has made the move because of the increased number of visitors from Jamaica and Haiti. This week, the U.S. government and Panama announced increased security along the reported routes being taken,
which they have identified as a route for illegal migrants. And we are trying to be proactive and bring to the attention of Jamaicans that this is not a good decision to take. It is extremely risky for you personally, but it also affects the reputation of our passports, which we have been working hard at strengthening.
Jamaicans in need of loan from the Students' Loan Bureau should have access to a pool of $4.24 billion. The SLB has confirmed that it will continue to provide funding to students attending 34 approved tertiary institutions through 3 loan products during this fiscal year. This is $312 million more than the programmed sum for 2022-2023, according to the Jamaica Public Body's estimates of revenue and expenditure for the year ending March 2024. An overall $6.13 billion was budgeted for disbursement last year. The sum included arrears of $2.2 billion for payment to institutions by the end of the period on March 31. The Department of Correctional Services, DCS, will be placing greater focus on successfully reintegrating rehabilitated offenders into society. State Minister in the Ministry of National Security, Xavier Main, who made the disclosure, said this forms part of the government's thrust to reform the correctional services. The state minister was speaking during a recent official opening of the renovated Block B dormitory at the Rio Cobre Juvenile Correctional Center in Spanish Town, St. Catherine. As part of its rehabilitation program, the DCS provides literacy and numeracy education at the basic, intermediate, and advanced levels to inmates and wards. The DCS also facilitates various vocational skills, including carpentry, farming, metalwork, tailoring, auto mechanics, cosmetology, computer studies, home economics, plumbing, masonry, and electrical installation. A rehabilitation grant is available to persons who have been incarcerated for at least 1 year. And it's time now for the business report from Danita Rodney.
Global payment giant MasterCard recently announced that it is accelerating efforts to remove first-use PVC plastics from payment cards on its network by 2028 as part of its sustainability commitments. Starting January 1, 2028, all newly produced plastic payment cards will be made from more sustainable materials, including recycled or biosourced plastics, and approved through a certification program. The company also says it will support its global issuing partners through the transition away from virgin PVC to becoming eco-certified. Now for your market updates. In foreign exchange trading for Tuesday, April 11, the US dollar sold for an average of $153.16. The Canadian dollar ended trading at $113.08. The pound sterling traded for $188.83, and the euro sold for an average of $170. In JSE trading, the JSE index declined by 187 points. The junior market index advanced by 4 points. The combined market index declined by 132 points, and the All Jamaican Composite Index declined by 1,193 points. Overall market activity resulted from trading in 125 stocks, of which 50 advanced, 50 declined, and 25 traded firm. Stocks advanced for 138 Student Living Jamaica Limited, AMT Packaging and Paper Company Limited, and Virgin Paints Jamaica Limited. Stocks declined for Access Financial Services Limited, Barita Investments Limited, and Cargo Handlers Limited. Trading firm were Blue Power Group Limited, Caribbean Flavors and Fragrances Limited, and Community and Workers of Jamaica CCU Deferred Share. The overall volume leaders were Image Plus Consultants Limited, Wigton Wind Farm Limited Ordinary Shares, and Lindmers and Barnes Limited with over 1 million units. In regional stocks, Zero Securities traded in Trinidad and Tobago. On the Barbados Stock Exchange, Goddard Enterprises Limited was the sole security trading 10,000 shares. In regional business, the International Monetary Fund is predicting that Antigua and Barbuda will be the third fastest growing economy in Latin America and the Caribbean. More from ABS News.
Here's what we're looking at. Real GDP growth in Latin America and the Caribbean based on the IMF's projections for 2023. Of course, we're in April 2023. This is essentially annualized forecast by the IMF. Real GDP is GDP, nominal GDP accounted for inflation, so it is adjusted for inflationary impact. Guyana expected to, not surprisingly, lead growth in Latin America and the Caribbean for 2023, 37.2%. This is actually put at much higher based on other forecasts. The IMF is notoriously conservative in its forecasts. Some other forecasts like ECLAC and the IDB and the World Bank project this to be much higher than 37.2% for Guyana. But either way, it is by far and away the leader in growth in Latin America and the Caribbean in 2023. St. Vincent and the Grenadines, according to the IMF's forecast, comes in second in LAC at 6%, Antigua Barbuda 5.5%. Bearing in mind, put an asterisk beside this because the ECCB, that's the Eastern Caribbean Central Bank, has projected growth of 9.4% for Antigua Barbuda in 2023. So the IMF's forecast, as we said, usually far more conservative than the other forecasters. Certainly more conservative than the ECCB, certainly more conservative than ECLAC, that's the United Nations Economic Commission for Latin America and the Caribbean. So that's a picture for 2023. These are the top three leaders in real GDP growth. Let's look at a picture for 2024. Same Latin America and the Caribbean. Again, Guyana expected to grow even further in 2024, 45.3% in 2024. Antigua Barbuda now becomes the second fastest growing economy next year, 5.4%. St. Vincent and the Grenadines, which was expected to grow by 6% this year, falls down to 5% in 2024. So certainly, again, significant conservatism in relation to the IMF's forecast. But even with that level of conservatism, Antigua Barbuda expected to be one of the fastest growing economies in Latin America and the Caribbean.
In international business, we take a look at the International Monetary Fund's World Economic Outlook for April 2023. In market data for oil prices steadied as the market waited for U.S. inflation data later in the day that will likely influence the Federal Reserve's policy on interest rate hikes. Brent crude gained 14 cents to $85.75 a barrel, while West Texas Intermediate crude rose 10 cents to $81.63 a barrel. And that was the business report on PBCJ. I'm Danita Rodney.
In regional news, CEO of the Ministry of Immigration, Gilroy Middleton, says Jamaica is yet to respond to his country's decision to invoke Article 226A of the revised Treaty of Chaguaramas. The move will allow for the Minister of Immigration to immediately impose a visa requirement for Haitians and Jamaicans visiting Belize.
In respect of the Jamaicans, the numbers are similar, but we haven't reached a tipping point as in respect of the Haitians. In respect of the Jamaicans, we've had some 1,673 Jamaicans entering via the PGIA primarily since January 2022 to date. Of that 1,673, we've had some 778 depart through one of our legal border crossings. So that left some 895 Jamaicans who have not exited through our northern border point of exit or any other of our formal border points. So the Haitians, 1,974 unaccounted Haitians, Jamaicans, 895 unaccounted Jamaicans since January 22. So that's about 50% less Jamaicans. Hence, we're not looking at that visa restriction for the Jamaicans. Honorable Eamon Courtney will be working on a subcommittee of cabinet in terms of the ministers, and then the CEOs and the technical individuals will be working and looking at the issues. In this case, the analysis show that it may relate to smuggling. So that will be reviewed, and it must be noted that we are not attempting to restrict any Jamaicans or Haitians who intend to come to Belize legitimately. These individuals have rights under the Treaty of Chaguaramas, which will be respected and which, from an immigration point of view, we will facilitate. However, we must ensure the national security of Belize. There were some reports that we have added additional restrictions to Jamaicans. I must note that these reports are false. What Honorable Eamon Courtney noted is that the subcommittee will be formed to address immigration issues on a whole. The Ministry of Immigration will be liaising with the Ministry of Tourism from the perspective to look at how we could address these issues.
Speaking during a press brief on Wednesday, Jamaica's Minister of Foreign Affairs and Foreign Trade, Senator Kamina Johnson-Smith, said her team is waiting for additional data from the relevant authorities to get a clear picture of the situation.
We do not have PICA-validated figures as yet, and when we have those, we will share them as well so that there can be a sense. Again, you can see that the numbers are not massive when you consider what's happening generally in Central and South America, but it is still cause for concern for us, relatively speaking, and one which we're seeking to bring to attention.
More money for local artists. That's the promise from the Trinidad and Tobago Copyright Collection Organization, following Tuesday's signing of a memorandum of understanding between the Twin Island and Jamaica, South Africa and Canada. Terry Brown Campbell has the details.
Local and regional artists now stand a better chance of receiving royalties for their work in Trinidad and Tobago and in the wider world outside. That's the word from President of the TNT Copyright Collection Organization's President, Aston Isaac.
This is a fantastic exercise, a fantastic opportunity for creatives in general. They now have the opportunity to have their works really tracked and really assessed in a way that we can really add that value in remunerating them for the use of their works and licensing.
The TTCCO signed a memorandum of understanding with the Jamaica Music Society and the South Africa Music Performing Rights on Tuesday. Mr. Isaac said in a few days a memorandum of understanding with Artistic Canada will be signed.
It also lends for the opportunity for creatives from Trinidad and Tobago who traditionally may have had content in that space or utilizing in Jamaica or in Canada or in South Africa, and they were not able to identify and track that content to be remunerated for such. Now they have that through this bilateral agreement, which speaks specifically to artist content.
The president of the TTCCO said his organization has 4,000 registered members with an extensive body of work. He added, with the MOUs, an additional 100,000 bodies of work have been added from Jamaica and more than 2 million pieces from Sampra in South Africa. Terry Ann Brown Campbell, TTD News.
Antigua and Barbuda's National Youth Parliament Association is seeking to forge closer linkages with its counterparts in the United Kingdom. More from ABS News.
The association is now in dialogue with the office of Sir Lindsay Hoyle, Speaker of the UK's House of Commons, with the hope of creating greater opportunities for the Youth Parliament. President of the association, Kamali Mannix, provided the update on the heels of Sir Lindsay's recent visit to Antigua and Barbuda.
One of the key things that happens in terms of youth work in the United Kingdom is every year you have a UK Youth Parliament, similar to us. They draw young people from the 650 constituencies across the United Kingdom and they bring them together. Wow. Since Sir Lindsay has become the Speaker of the UK House of Commons, he said, let's not just restrict it to Britain, but let's extend it to the overseas territories.
Mannix was quick to seize the opportunity for Antigua and Barbuda to benefit.
During our discussion, I said, ooh, open door. Open door.
Yes.
I said to Lindsay, so, you know, you guys have extended it to
these
the UK, you've extended it to the territories, you can also extend it to the Commonwealth.
He says Sir Lindsay not only welcomed the idea, but immediately gave the contact information for his office and gave approval for the commencement of discussions.
It's now for us to explore the opportunity of, one, participating in their youth parliament whenever it sits, and or, I'm a favor of and, going to Britain to see the operations of their parliament.
In international news, the United States is investigating how dozens of top-secret military documents ended up on the internet, some of which claims to show South Korea reaching a deal with Washington for weapons that could be used by Ukraine.
As one of its strongest allies claims that South Korea has been spied upon by the US, has sent the administration here into damage control overdrive. South Korea's defense minister has spoken with his US counterpart to reassure each other their alliance is as strong as ever, both pointing out they believe a number of the leaked documents are false.
Many of the disclosed documents are fabricated, and our joint assessments are consistent with each other.
But the government hasn't said if it believes the documents relating to South Korea are fake or genuine.
They purportedly relate to sensitive government conversations about the provision of artillery shells needed by Ukraine. Seoul doesn't supply them directly so as not to anger Moscow, but South Korean officials are alleged to have discussed ways of supplying shells indirectly through third countries.
The alleged discussions are not that revealing, but what's more concerning here is the fact that they might have come through eavesdropping.
We believe that if it's true, it would be a very disappointing situation that damages the trust-based alliance between Korea and the US.
It's also led to questions about how the security-conscious administration of President Yoon Suk-yeol could allow itself to be spied upon, and whether his decision to move his office away from the traditional Blue House compound allowed a security lapse.
When he got elected last year, unpreparedly moved out of that long-established presidential office and moved to this current former military headquarters. So the opposition party has criticized, among many other reasons, the security issues.
It's all the more embarrassing coming just 2 weeks before a long-anticipated summit in Washington with US President Joe Biden, seen as a reward for South Korea's unstinting loyalty, when the two men will be smiling for the cameras in spite of alleged one ally has been spying on the other. Rob McBride, Al Jazeera, Seoul.
In sports, Cricket West Indies CWI has named the squads for the upcoming Headley Weeks Tri-Series. Team Headley, named in honor of George Headley, will be captained by Joshua Da Silva, the wicket-keeper batter. Team Weeks, named in honor of Sir Everton Weeks, will be led by Alec Athanes, the left-handed top-order batter. The two teams have been drawn from the leading performers in the 2023 West Indies Championship and those deemed to be on the fringe of the Test team. Boxing force Sakima Mullings, in an interview with the PBCJ Sports team, is stating his intention to rebuild the support, enthusiasm and success of the sport as the boxer and coach faces his last year of his master's degree in sports management. His studies are being done at the University of the West Indies and they end this year. We now join Maya Chung for the final in a two-part feature on Sakima Mullings' intentions to bring back boxing a greater scale in his home country.
The team that Sakima is currently working with include IBA certified coaches who are themselves working towards breathing new life into the sport of boxing here in Jamaica. One of these people is Felipe Sanchez, who in February of this year took a contingent of Jamaican boxers to the Dominican Republic to compete, where, according to Sanchez, the vibrancy of the DR boxing sector is where Jamaicans want their boxing sector to return to.
When COVID came, remember that we couldn't even be speaking at this distance. You know, we'd be doing a fatal talk. So boxing died completely. And after it died, the people who really love the sport and can't live without practicing it get together, and I include Sakima in this because we said, hey, we need to get our different boxers together, at least to spar, keep them sharp. You know, Sakima's a superstar. Anywhere you go with Sakima, people go to him and be like, oh, Sakima from the contender, you're my favorite fighter. So seeing that entrenchment with the youth, and furthermore in Olympic Garden where they look up to Sakima, like when Sakima coaches them, they're like, I'm learning from the best right now, the best fighter. Not the coach, he's a fighter. So I would definitely say that he has a lot of influence. Children and fighters, older fighters as well, all look up to him. I think Sakima just always loves the sport and has always tried to keep it alive. For example, a testimony I can give is at Sugar's Gym, we did a Labor Day project which he spearheaded.
This is
in Olympic Gardens. I think this is 2021, don't it? Or is it 2022? 2022, right? And we came together, we had like a family sports day, we had a little bit of sparring, you know, a little bit of fun, and we got to renovate the outside part of the gym because it was in a bad state at the beginning, and this was like a second phase of renovations. And, you know, other than that, I'm just coming to the gym and train. You know, come in and train, and it's different, you know, when someone is when you see Sakima teaching them, he's teaching them not amateur stuff. He's also teaching them, you know, some high-level IQ, like, this is how you close out the ring. You have to think when you fight. It's not just... So I think, you know, other than just having the positive mentorship skills that he has, I think that his professional fighting is a big asset. And he's showing the youth, hey, guys, I've been through everything. I've been a champion, I've been on TV. So for them to see that happening and for them to get that direct guidance, you can see it in their eyes how they listen and how engaged they are.
The men say that boxers who want to find success will inevitably end up leaving the country to fulfill their desires in the sport if things do not change. Mr. Mullings wants boxing training gyms that are child-friendly as well as safe for children interested in the sport.
Ultimate, then from there it takes funding. You know, so that there is a five-pillar system where there has to be recruitment of boxers, there has to be recruitment of coaches, there has to be regular competition, there has to be
funding support.
Funding and support, and then within that also you have to have all of the auxiliary with the referees, with the technical officials, and the and all the other officials that are going to make boxing happen.
Mr. Sanchez added this.
I agree completely with Sakima, and I think one of the most important things is that you need to build good boxers. So you have to start from the amateur levels. If you don't have a grassroots movement, if your amateur boxers are not good, then you don't get good professional boxers, right? And the ultimate goal of an amateur boxer is to go to the Olympics. So I think without no coaches, there's no boxing. But then there needs to be funding. So I think once boxing is in the limelight, once there are shows and promotions, this will incentivize promoters to come out and put on a boxing show. It'll make the youths, the children be, you know what, I'm going to try boxing. So I think those are two crucial steps that are necessary. And in my own experience, we traveled with a 71 kilometer with Team Jamaica to Domrep to a competition that's been going on for 42 years.
When did you
This was February. This was February 20th, and 10 different countries went. So, you know, just like in New York and America, they have Golden Gloves where they discovered Muhammad Ali and these guys. In Domrep, this tournament, we need to be exposed to more of these tournaments. We need to have more elite, high-level fighters to take there and represent Jamaica on a high scale.
And the coaches have the support of the boxers. According to the #1 ranked heavyweight boxer in the country, Jermaine Breezy Richards, after the decimation of COVID-19, the sport needs this to kickstart the sector towards rebirth.
Boxing organization really start believing in the boxer them, the Jamaican boxer them.
And that's the news on PBCJ. I'm Simone Absalom Gale. You can follow us on our social media pages at PBC Jamaica. Thank you so much for watching.
Welcome to the CCRP Silver Club Series.
Our mission really is to celebrate our seniors.
That person in your home must have an understanding of the needs of the senior.
There's a loss of balance you find there, falling out of chairs.
When the older person says, I'd like to go for vaccine, they tell them no.
I think that seniors are quickly becoming digital adopters.
Stress is a leading contributor to Alzheimer's.
A major area in high school for me was IT and EDPM. I did that for 2 years, and from then I realized that there was a drive for more of technology. So I decided to take this step.
Riddle, I bet you don't know who I am, do you? Wow, you were able to guess so fast. You're right, I am an ant, but I'll bet you don't know exactly what kind of ant I am. I'm a green tree ant, as are all those ants. We are one big, busy family. We mainly live in the forests of Australia, but we also live in other parts of the world. Other types of ants live in these woods as well. Take, for example, our neighbours, the bulldog ants, who live underground. Bulldog ants are very dangerous to us, as they are very strong. Sadly, sometimes we have to fight them. Though they are much bigger than us, we are smarter than they are. We have many proven ways to protect ourselves from the strong enemy. Ants are at their best working above ground all together. We create huge communities. My family, the green tree ants, make our nests in the trees and construct the nest with leaves. Each individual ant has a specific job during the construction process. We naturally help each other. Since the leaves used for the nest building are much bigger than we are, we must work together to manipulate them. Look how organised we are. Everyone knows what to do. I've heard that humans build their nests as well. You help each other and create great structures. We build our nests so our queen can go inside and lay her eggs. When the eggs hatch, an ant larva emerges. But before it will pupate, it produces silk, which we will use to connect the leaves. The silk is used to hold our nest together. Some pupas, new ants, just like me, are fully formed. I hatched a few days ago in this beautiful forest. Are you surprised that I know everything already? That's because we are born knowing everything we need to know as ants. We don't have to learn a thing. Watch out! Watch out! There's an intruder! He's hungry and wants to eat us. Hurry, hurry! We must stop him. It's a trapjaw ant. He's got huge jaws, or mandibles. Everyone at the alert. Now watch how we scare him off. When we feel threatened by an enemy, we have poison in our bodies which we spray on them. That's it! We won! Oh gosh! Now it looks like the bulldog ants want to attack us. Well, they do live really close to us. Hope they won't bother anyone. We'll have to prepare for another fight. These ants have very good eyesight. The rest of us don't see that well. That's because we don't really need to. In order to communicate and maintain orientation, we use scent traces from our bodies. When we find something to eat, we'll mark the path by leaving a scent. Other kinds of ants use different ways of communicating, such as stridulation or tasting. In our communities, our queen is the most important ant in the nest. She lays the eggs from which male ants and worker ants will come. The job of the workers is to care for our nest. They build and protect the nest against enemies. The male ants are in charge of reproduction. The workers care for our eggs and for the hatched larvae, like this bulldog ant. See? While our new nest is being built, we must be very careful that no one attacks our queen. We are very vulnerable when we are not all together. Looks like our neighbours got some secret news. I bet they are planning to do something bad to us. They saw us build a new nest. and I think they want to find out if there might be something good inside that they can eat. From the moment we finished building our nest, someone tried to sneak into our pantry. I'd better go and warn the others before it's too late. Oh gosh! Another trespasser! It's a Jack Jumper ant! Attention everyone! The invaders are coming from the other side! They have very dangerous poison, so we'll have to outsmart them. The bulldog ants are paying close attention to the situation. All green tree ants gather here. The battle has now begun. Don't worry, by working together, we're sure to beat them. The transmission of signals is a very important part of winning the battle. It's over. The enemy had to retreat. Let's enjoy a bit of peace for a while. After what they saw, I would think the bulldog ants wouldn't want to attack us anymore. I hope it'll last a good while so we can concentrate on our work. Did you notice how skilled and flexible the ants are? Ants can be compared to the work of an artist. Or even a pilot. Ants are incredibly strong. We ants can carry many times our own body weight. Most humans can't do that. Just imagine, would you be able to lift someone bigger than you over your head? Would you be able to lift a few people at the same time like that? Ants are able to actually combine our individual strengths together in order to build a complex structure such as our nest. Ants are built for working long and hard. We do whatever is good for us all. When I collect food, it's always intended for everyone, not just for me. No one does anything just for himself. We don't do anything just for fun either. All of our time is spent caring for our nest. We also build many paths that lead into our nest. The ants that live in dry regions are able to carry drops of water to their anthill. I love being an amazing ant. All of us are very proud of our anthill. It seems that the bulldog ants won't try anything against us today. They're probably scared of our great combat tactics. I don't blame them. We're really good. When the fighting has stopped and the woods are peaceful, we can start to move some tasty food into the pantry of our new nest. Here it is! Look what we have found! Why are you making faces? We love it! It's so delicious! We just had different tastes from you. Take a good last look at us working together. Together, we create something no single ant would ever be able to create. And now it's time to bid you farewell. Goodbye, and don't forget your friends, the ants.
Little germs do.
Pink eye running belly even flu. Germs can make them happen to you.
Put germs on our manners with these. Cover your mouth when you cough and sneeze. Always wash your hand with water and soap. Keep dirty hands from your eyes and your nose and your mouth. You don't want to be sick, take care. Practice every day, no germs round here. A message from the Ministry of Health.
Virgin, the road signs make the traffic environment safe. The green light means go. Red means stop.